Thanks for your time. Yeah. At least that's my. That's what I plan to tell. Yeah, that's what I plan to tell.
Put that somewhere on your suit where it's not gonna bother you.
Yeah.
Thank you.
Very fancy.
And how many witnesses did you say?
We have 3 substantive witnesses for the bench trial.
Okay,
We have one.
are they all in the room
They are not.
or any of them in the room?
No, they will all be here in person.
Oh, no, okay.
Yes.
Alright, I'll just. Please. Also, come up talk for me. Just say anything.
Testing, anything.
Good afternoon, sir. Now, how sensitive are these things for table conversations? If I put it over here, if I'm having a conversation with co-counsel or with my client, are you gonna pick that up?
I would just leave it on, and when I do the transcript, like, if you're not loud, like, if I
Right.
can hear you whispering, it's
Okay.
silent, so it doesn't go on.
Okay.
So I know the difference between what should be on there and what's not, so it's just.
Okay.
Yeah, well, I accept it. Yeah.
What?
Family comments. Nothing. I didn't know if we were gonna use it. But no, I don't think I should. Using that one of you. But it wasn't, yeah.
What
And
is
I-
it?
But I don't think we had to be. She just said to date, this is how many hours we didn't, everyone see like, is this attributable to the.
Right, did we include? Missing out in the bill? Was it called?
No, I can, this very only.
Okay.
Because we have a change.
What?
Yeah, change.
Right. That's. So.
The first one?
Yeah. Evacuation footage.
You all set up? You're not. You can stay seated. Okay. Well, let's talk logistics while everything's getting set up.
You're almost it.
Okay. Well, we'll just get on the record. This is 24cv007261. It's VBT versus John Dunn. If I could have the appearances first on behalf of VBT.
Good afternoon, Your Honor. Matthew McMaster here for VBT LLC.
Good afternoon, Mr. McMaster. Nice to meet you. Welcome aboard. And on behalf of Mr. Dunn.
Good afternoon, Your Honor. Sean Ryan on behalf of John Douglas Dunn, along with my co-counsel, Virginia Eith.
Last name is Ice.
Eith. E-I-T-H.
E-I-T-H. Ith. Got it. Okay. It's even listed here on the pretrial order. We are here to talk about attorney's fees and the basis for attorney's fees and the reasonableness of attorney's fees that are being sought by Mr. Dunn. So Mr. McMaster, my understanding is the posture here is you are opposing the fees in part, either they aren't justified, they're not reasonable, or they're not tethered to something that was set forth in the pretrial order. Mr. Ryan is advocating for the award of fees. So I'll be starting with him, letting him say, here's why I think we're entitled to them and here's why they're reasonable. But I think that's the focus of today is attorney's fees. Is there more to it than that?
Yes, Your Honor. I think we're also here for a bench trial on Mr. Dunn's counterclaim.
So not just fees.
Correct.
Okay. Well, all right.
And so my plan for today with your agreement was to start with the motion for fees, argue that, and then proceed into the bench trial on the counterclaim for tortious interference only. Mr. Dunn is abandoning his slander of title counterclaim.
Okay.
Tortious interference along with 13.611 attorney's fees, and there's a claim for punitive damages.
13.611, not 13.111?
Correct.
Okay, so tortious interference, 13.611, and then the punitives would flow if I find that there was tortious interference from that.
Yes, Your Honor.
Okay, and that's the universe.
That's the universe of the counter.
Okay, those are the counterclaims, but then you are also going to argue something about fees, and that's fees.
The fee motion is for prevailing party attorney's fees under the lease contract based on Mr. Dunn being the prevailing party on VBT's claims under the contract. Your summary judgment order entered in July of last year completely disposed of all affirmative claims that VBT had asserted in this case.
Got it. Okay. Mr. McMaster, is that your understanding of what we're working through today?
It is, yes, Your Honor. And if I had a preference of order, I would prefer that we do the counterclaims before the fees. And there are threshold arguments to decide if fees are even appropriate. The reason I would say do the counterclaims first is my expectation is that fees are going to be a larger portion of the hearing. And we won't even get to the counterclaims if we start with those, and I'm not quite sure we'll finish that motion. So I prefer getting through the counterclaim because I'm pretty confident we can.
Okay.
And then do the fees secondly.
Okay. Mr. Ryan, any reason to do it one way versus the other?
Yes, it would be my preference, and the reason to do the motion for fees first is that I believe, argument-wise, from a substantive liability perspective, is very short. And in terms of the reasonableness of fees, that will be testimony from me, directed by Ms. Eith, which will be brief, and then obviously an opportunity for Mr. McMaster to cross-examine me. And that should be the end of the fee motion.
Okay.
On the counterclaims, I do have Mr. Dunn as a witness, and I have 2 witnesses from Hickory here as well to testify.
Okay.
And so that should take a little bit longer, but still should only be, at least from our side, an hour and a half to 2 hours of testimony.
Okay. Why does it then, I guess I'm hearing Mr. McMaster say, let's deal with I guess he's saying the reverse though, that he thinks for some reason the prevailing party fees argument would take longer.
Right, and to address Mr. McMaster's statement regarding the threshold issue on the counterclaims, the prevailing party attorney's fees and the counterclaims are completely distinct.
Understood.
Animals.
Okay. All right. But we would be able to release people sooner if we did the counterclaims first, because we've got witnesses who are sitting around for that. You've got to be here anyway to handle both.
Yes, Your Honor.
Okay, let's start with the counterclaims.
Okay. Then I will start with just a very brief opening and overview.
Great.
Less so than if I was in front of a jury, Your Honor, but.
Okay, and you're mindful of the fact that I'm familiar with the relationship between the parties, already litigated the motion for summary judgment, et cetera. So
I will be, it is very brief, Your Honor.
Okay.
Trust me, just to give you an overview. So we're starting with the counterclaims that Mr. Dunn has asserted against VBT. As I mentioned at the outset, we are abandoning the slander of title counterclaim and proceeding today on the tortious interference counterclaim and related claims with respect to attorney's fees and punitive damages. As you are aware, given your familiarity with the case, Mr. Dunn owns property in Forest Park, Georgia at 5845 Lees Mill Road. Mr. Dunn leased that property to VBT beginning on January 1st of 2021. The lease term expired on March 1 of 2024. As you are also very well aware, as the end of VBT's lease approached, Mr. Dunn received an offer from Hickory Real Estate Acquisitions, from HREP Acquisitions, which we'll be referring to as Hickory or HREP throughout today's proceedings, to purchase that property. Mr. Dunn accepted and entered into a commercial sales agreement with HREP on November 16th of 2023. That commercial sales agreement provided for an inspection period running through January 5th of 2024 and a closing date of January 5th, 2024. After signing that agreement, Mr. Dunn notified on November 17th of 2023 VBT and its principal, Mr. Smith, that he had entered into an agreement to sell the property. Upon hearing of the commercial sales agreement, VBT had 2 choices. 1, cooperate with the inspection process and work with HREP and Mr. Dunn to find a solution where VBT could remain a tenant, or throw up roadblocks, delay the inspection timeline, threaten HREP and its employees, and refuse to vacate the property. We're here today because VBT chose the latter. So today, Mr. Dunn will present testimony and documentary evidence of VBT's wrongful conduct in delaying Mr. Dunn's contract with HREP, all of which shows that VBT tortiously interfered with the commercial sales agreement with HREP. Specifically, that evidence will show that VBT, through its principal, Mr. Smith, repeatedly delayed HREP's required inspections under the CSA, threatened HREP during an initial attempted inspection on November 27th of 2023, acted erratically during the December 9th, 2023 inspection that was finally able to be arranged, made repeated calls to HREP and its employees, and showed up uninvited to HREP's offices to intimidate and further attempt to prevent HREP's purchase of the property, and refused to vacate the property following the expiration of the lease term, a refusal that continues to this day as he remains in possession. All of this conduct was improper and without privilege. VBT purposely took these actions to delay or otherwise prevent the sale of the property. He was successful. Evidence will show that VBT's conduct directly caused the delay in closing of the commercial sales agreement, a closing which still has not taken place as of today. Evidence will further show that Mr. Dunn suffered damages as a result in the form of continuing carry costs associated with his ownership of the property beyond the February 1st, 2024 closing date, and the loss of use of the expected $912,000 in proceeds from the sale he would have received at closing on February 5th, 2024, absent VBT's interference. All told, Mr. Dunn seeks over $220,000 in compensatory damages arising from the tortious interference. Mr. Dunn also seeks attorney's fees resulting from the prosecution of this counterclaim under 13611. Tortious interference as an intentional tort inherently invokes a species of bad faith authorizing such an award. Finally, there is also a remaining claim for punitive damages based on the intentional conduct underlying the intentional tort. Quick roadmap for today. We have 3 witnesses in support of the TI claim. First, we will call Mr. Dunn to testify, followed by 2 employees of Hickory, Mr. Costin, its principal, and Mr. Bush, an employee who was present when Mr. Smith visited the property unannounced. Then
You say visited the property, meaning visited Hickory's offices?
Hickory's offices, yes, Your Honor. And then normally with a jury, I would advise the court to bifurcate the attorney's fees issue under 13611. Since we're here with you, once I'm done with the substantive witnesses, we'll go ahead and call me for reasonableness on those fees.
Okay.
Thank you.
You're welcome. Mr. McMaster, anything you want to say in opening?
Yes, Your Honor. I'll be brief, though. This is the year 2026. Proving cases like this are much easier. We have cell phones, we have cameras. If whatever they're saying happened, we're going to see it. If it didn't happen, we're not going to see it. That's our position. They cannot prove all the elements to a tortious interference. One, they don't have the evidence to prove what they allege in their opening. But there's more elements that were missed. I had to go through the docket in a very short amount of time and learn this case, learn this area of law, and they can't meet all their elements. My first instinct was to file a slap motion, but we're well beyond that. You had a dispositive motion scheduling order, so we can't do that. But my client was exercising his right to petition, his right to free speech. And in addition to that they don't meet their elements because he wasn't a stranger to this contract, not for 5 seconds. His name's in their contract. I have no idea how this case got this far, but it did. I came in late. Our position is they cannot prove their elements to any of their claims. If they could, again, technology would be there for it, and it just isn't. So that's my brief opening. And I guess we're saving for the argument for the motions fees, right?
Yep.
Okay. But that's it. Thank you, Your Honor.
You're welcome. Thank you. All right. So it sounds like, Mr. Ryan, you are ready to call Mr. Dunn.
I am.
Great. Mr. Dunn, come on up, please. So stay standing while she swears you in.
Raise your right hand. Do you swear from your testimony like you gave it in the case that the truth will help you God?
I do.
Go ahead, state and spell your name for the record.
Don Douglas Dunn Jr.
Good afternoon, Mr. Dunn.
Good afternoon.
Do you own property in Clayton County?
I do.
And what property do you own in Clayton County?
It's at 5845 Lees Mill Road in Forest Park.
Is that the property we're here talking about today?
It is.
When did you purchase the Lease Mill property?
1997,
And for what purpose did you buy it?
to locate one of my bus dealerships in there.
Can you describe the property for us, just to give us a little bit of background?
Yeah, it's about 2 acres, 7,100 square feet with some offices in the front, warehouse in the back that was used as a shop. It's right on I-75, the frontage road.
Okay. And you mentioned the use of the space for one of your bus dealerships. Did you use both the front office space and the garage space?
I did, in the lot as well, yes.
Okay. And did you at any point lease out the garage space to someone who wasn't your business?
Yes, yes. Over the years, I bought and sold many dealerships, and that piece of property was involved, or the dealership was involved in some of those sales. So subsequently, I ended up leasing it to some different parties over the years.
Okay. And did there come a time where you stopped using the Lee's Mill property for your businesses?
Yes, in 2021.
Okay. And why did you stop using the property?
In August of 2021, I sold all my dealerships, and we stopped using the property at that time.
Okay.
The front half of it, yes.
Now, I will circle back to this, but I believe the lease that we're here partially talking about was a January 1st, 2021 lease. Does that maybe change your recollection on when you sold your business?
Yeah, I actually sold the business in 2021.
Oh, okay.
Okay, but I leased the front half. The offices were a sales office for my dealerships at the time. And I had a tenant in the back operating the shop.
Okay. So at some point in October 2020, were you looking to lease the entire property?
Yes.
Okay. And why was that? Did there come a time where you were looking to relet from the tenant that you had previously been leasing to?
Yes, the tenant notified me he was in the process of selling his business. And so then I was going to have to go out and find another tenant to go into the business.
Okay. And who was he planning to sell his business to?
To VBT, Ed Smith.
Okay. And when did you first come to speak with Mr. Smith about him renting the space at the property on behalf of one of his businesses?
That would have been in late 2020 when he did that.
And what exactly was Mr. Smith interested in leasing from you? The whole property or just a portion?
The whole property.
And did you end up leasing the space to Mr. Smith?
I did.
Okay. And who was the tenant under that lease?
VBT.
Okay. And is that the same company that is the counterclaim defendant in this case?
It is.
Okay.
Do you want to say that?
Yeah.
Okay.
I'm using defendants stickers, even though we're counterclaim plaintiffs, just for.
That's fine. As long as, then, Mr. McMaster, you are plaintiff stickers, if you need stickers,
So.
just so we don't confuse it further.
It's going to be marbles. It's a bit one. It's got release. Okay. Okay. Am I free to approach?
Yes, both sides are free to approach witnesses unless you hear me revoke it because you've done something you shouldn't. So feel free to move about.
Thank you, Your Honor. I have marked as Exhibit 1, the document. You can go ahead and take a quick look at that, please, Mr. Dunn.
Yes.
Thank you. So this says P29 at the bottom, but this is defense 1.
It is defense
What I
1,
should write on
P29, and we will use, we have a lot of stickers.
Yeah.
We will cover them in the future, and the copies we mark for you
Okay.
will be marked. That is a relic of a deposition sticker.
Okay.
Your Honor.
No objections to that.
Okay. Well, can you tell me what this document is?
Yes,
Mark,
this is
it
the
one?
lease agreement between myself and VBT
Okay,
that we entered into.
all right. It sounds like there's no objection, but I will formally tender that into evidence, Your Honor.
So it's admitted there was no objection.
Okay.
To the lease, yes.
Yes, to the lease. I have a question for you, Mr. Dunn. You said this is a lease. Is this the lease?
This is the lease.
Okay, there's not another one we're gonna hear about or another one that you've got in your back pocket that Mr. Ryan hasn't seen?
No, sir.
This is the lease.
This is
Okay.
the lease.
It's gonna make my life simpler.
And so so I think you answered my next question, but so I'll strike that, but when did the lease term start?
January of 2021, January
Okay.
1st.
And how long was the term of the lease?
The term was stated at 36 months, but the rent did not begin until March,
Okay, and when did this lease expire?
March 1st of 2024.
Of 2024?
Yes.
So it was sort of a 39-month lease, but there were these 3 months where something else may have been happening, but rent wasn't paid pursuant to this.
Correct. Rent
Okay.
was paid for those 2 months, first 2 months. Yes.
Okay.
All right, you can set that aside.
Okay.
So during the term of your lease with VBT, did anyone ever approach you to purchase the Lee's Mill property?
Yes, they did.
Um,
That was HREP,
okay.
Hickory Partners, yes.
Is that HREP Acquisitions LLC?
Hickory Real Estate, yes, whatever the.
Okay.
Partners.
And if you could speak up.
I'm sorry.
I'm back here.
Yeah, the chair doesn't have wheels, so you just did the right thing and then just keep the microphone part near your mouth and it'll work.
Sorry about that.
Right, we don't want you to roll off the platform.
Okay.
How did you hear about HREP's interest in your property?
I was contacted by a broker with King Industrial Realty, a company I was familiar with.
Okay, and did HREP ever formalize that interest in purchasing the property?
Yes, they did.
Okay. Around what time did HREP reach out to you regarding buying the property?
During the month of October 2020.
Of what year?
Excuse me, of 2023. Sorry. The dates are running together.
Fair enough. It's been a long time. So at the time that HREP reached out to you about purchasing the property, had VBT expressed any interest in staying in the property beyond the lease term?
I had not heard anything from VBT.
Okay. So did you then engage in negotiations with HREP to buy the property?
I did.
And what was the end result of those negotiations?
We entered into agreement in early November to purchase the property, a commercial
Okay.
sales agreement.
Mr. Dunn, you mentioned that in October of 23, VBT hadn't expressed any interest in extending the lease, but as I understand it, that was still 5 months away. And so unless there's something in the lease that says 6 months before expiration, tenant needs to talk about renewal. So I'm just trying to work through, I'm not challenging what you said, but it also doesn't seem particularly remarkable. Mr. Smith might have thought, you know what, when we get to the start of 2024, I've only got 3 months left. That's when I'm going to turn to Mr. Dunn and say, hey, could we get an extension and renegotiate this?
Yeah, so over the years, I really heard nothing from VBT.
Okay.
We had one lunch the year before and had not heard anything coming one way or the other.
Okay, you were getting paid and that's it? Or you weren't getting paid?
Well, sometimes we had conversations back and forth when sometimes payments were late.
Okay.
But
For the most part, you were,
yes, but I had no indication that he wanted to extend the lease or do anything else at that time.
okay, I didn't ask my questions, well, but you also had no indication that he did not want to extend the lease.
Correct.
It just hadn't come up yet.
I just assumed he would do the lease with me or the next person.
Okay. Oh, meaning Hickory. If Hickory was the owner, then.
Hickory's a real estate company, they want tenants. Yeah.
Okay.
And how much did Hickory agree to buy the property for?
$960,000.
Okay. And you mentioned you entered into an agreement in November, is that correct?
That is correct.
Okay. I'm marking a document as Exhibit 2.
Thank you.
Mr. Dunn, can you tell the court or describe for the court what this document marked as Exhibit 2 is?
Yes, it is the commercial sales agreement between myself and HREP.
Okay, and you recognize this agreement?
I do recognize this agreement.
Okay, and that is an accurate copy of the agreement that you entered into to sell the property to HREP?
It is.
Move to admit defendants Exhibit 2.
Any objection?
No objection.
All right, it's admitted.
So under this commercial sales agreement, did Hickory, and I'm going to use Hickory and HREP interchangeably, so forgive me. Did Hickory agree to buy the property subject to your lease with VBT?
They did.
And after your negotiations with Hickory, did you have an understanding on whether Hickory intended to work with VBT on VBT's continued tenancy at the property?
Yes, they wanted to retain him as a tenant.
Did that commercial sales agreement have an inspection period?
It did.
And how long was that inspection period?
I believe it was 30 days. 30 days. Let me check. I may not be right. 50 days. Excuse me.
50 days. Okay, sounds about right.
Sounds about right.
And I think if you'll turn to Section 6, you'll see that reflected there. Is that correct?
That is
Bold.
Bold. And did the sales agreement have an outside closing date?
I believe it was it February 5th? Section was that?
So the
30th. Yes, I see it in section 15.
What were you saying, Mr. Dunn?
It says the 30th calendar day following the expiration, end of the expiration, inspection periods.
Okay. And what would that have been if the inspection period closed on January 5th?
Probably the end of January, 1st of February.
What?
It would have been the end of January, 1st of February for a
Okay.
closing date.
Okay. Does February 5th sound correct?
It does.
All right. So we have our sales agreement with HREP. We're getting ready to sell the building. And why were you, just to educate the court, why were you interested in selling your building at this time?
I was at a point in my life, and still am today, of winding down a lot of my assets and, put it in a little more secure situation so I could take care of my family in the future.
Okay. So after you signed this agreement, did you notify VBT, your tenant?
Yeah,
Okay. And how did you do that?
by an email.
All right. I am marking Exhibit 3.
Thank you.
Mr. Dunn, do you recognize this document?
I do.
And can you describe this document to the court?
Yeah, it's my notification to Ed that I've entered into a sales agreement to sell the building. Explained a few things after that about what happened and how it came about, and just to let him know, and we needed to make arrangements to go from there.
Okay. And this is an accurate copy of that email?
It is.
Okay. Move to admit defendant's Exhibit 3, Your Honor.
Any objection?
Objection to self-serving hearsay, but it is allowed for notice to my client.
So I'll let it
It's an
in.
exception to hearsay
Okay,
for notice purposes, but not that the truth of the matter is certain, Your Honor.
okay. It's admitted.
Okay. And why were you notifying VBT that you had sold the building or entered into this contract?
I knew the lease was terminating, and he needed to get with the new owners and work out a potential lease with them.
Okay. Were there any requirements in the contract that you were hoping VBT would assist you in completing and reaching out?
Yes, we needed to come and do an inspection.
Okay.
Yes.
And when were you trying to set up that inspection?
We were trying to set it up, I believe, for November the 17th, the first day we were trying to schedule something. So,
So the same day that you sent this email?
yeah, we immediately tried to schedule it right there after the conversations were started.
Did you speak with Mr. Smith after you sent this notice email?
Yes, we did. We spoke over the phone.
Okay. And on that call, what?
Numerous times, yeah.
And on those initial calls, did he agree to an inspection date?
He did not.
And did you follow up with him to try to secure an inspection date on November 21st?
I did.
I am marking an exhibit 4. And
Thank you.
if you could flip through that. Mr. Dunn.
Yes.
Now, what is this document, Mr. Dunn?
This is a message chain between Ed and myself.
Okay. And are these text messages?
These are text messages. Sorry.
Okay.
Yes.
And what is the date range on these texts?
Good question. Looks like it starts off on November the 20th, ends up somewhere around December 6th.
And are these an accurate representation of the text messages between you and Mr. Smith during that time period?
They are.
Move to admit defendant's exhibit 4, Your Honor.
Any objection to defendants for text exchanges between your client, Mr. McMaster, and Mr. Dunn?
Okay, Your Honor. Okay, so I object on ground that that is not the full thread of texts. In other words, it's missing, has holes in it. We're not disputing that those are text communications between the parties.
Okay. If there are texts you want to submit, you'll be free to do that. If you think there's a Rule 106 issue about completeness, we could work through that, but I don't know that that makes this inadmissible. I mean, it might subject Mr. Ryan to some embarrassment if you've got texts that have Mr. Dunn saying, I'm sorry, I'm backing out of the CSA with Hickory. I've done you wrong, Mr. Smith, and I take it back. I'm guessing that's not out there.
Probably not if they're not admitting it. 1 second, Your Honor, I may get the same kickback.
Okay.
We have no objection.
All right. Defendant's 4 is admitted.
Thank you, Your Honor. So did you send, looking at this defendant's exhibit 4, it appears you sent a text message on November 20th.
It does.
And why did you send that text message?
Again, I was trying to set up the inspection.
And did you ever get a response to this November 20th text from Mr. Smith agreeing to an inspection either on November 21st or any other date?
No, I did not.
Okay. How did Mr. Smith respond?
Mr. Smith claimed that he wanted to buy the property. I needed to talk to him about buying the property. He was upset I was selling it to someone else. We talked through those points that this has already happened. This has already been done. I've not heard from you in over a year. And I need to get the inspection done because this deal is done.
Did he respond to your text with a text?
He
Mr.
responded
Dunn?
to my text with it. Well, yes, there may have been some phone calls in there as well that he called.
Okay.
But
And
yes.
did he ever acknowledge your text via text?
No.
Okay.
Who is TJ Costin? Does that name mean anything
TJ
to you?
Costas, yes, he's the principal of Base Rep.
Okay, so that's a Hickory person.
He's a Hickory person, yeah.
All right.
He was the guy trying to get to come do the inspection.
And just to cut to the chase here, it seems like Mr. Smith in the end did say yes, they could come by for an inspection. If we go through this,
He did.
he ultimately says, could it be on Saturday?
Yes.
And you said, sure, what time? And she gives you some windows.
There's a lot more of the story in between there.
I don't want to skip over it, but I also don't need to wade through all this if
We're
you're.
not gonna wade through the individuals, but I'm gonna hit some highlights.
Okay,
Yeah.
all right.
All right, so to your understanding, did Hickory attempt to inspect the property the week of November 27th?
They did.
Tell the court about that understanding.
It's my understanding that they showed up to look at the property and were turned away.
So did any inspection occur that week of November 27th?
No, it did not.
Did you continue to reach out to Mr. Smith to try and get an inspection set?
I did.
Okay. And how did you do that?
I continued to text message him and ask him if we can get something set up and done. He did not respond for days at a time.
Did you eventually have to send a sternly worded text?
I had to say, this is going to happen one way or the other. He was letting me know he thought it would disrupt his business if we came and inspected during business hours. So he made it as difficult as he could and set us up for a Saturday morning, 7:30, December the 9th.
Okay. So is this December, if you look at the page at the bottom has a label, VBT 652.
BT 652. Wait. Okay, I got it.
There's a text message here where Ed, I believe, or Mr. Smith is responding to your request for an inspection, and this is dated December 6th of 2023. Is that correct?
That is correct.
Is that the first time since you notified him on November 17th that Mr. Smith agreed to take steps towards scheduling the inspection?
Yes.
So did that December 9th inspection occur?
It did.
Okay. And what date, you mentioned that was a Saturday?
Saturday morning at 7:30. Yes.
7:30 a.m.?
Yes, sir.
Okay. Now, did you have any issues accessing the building who all attended that December 9th inspection?
TJ, and I believe 3 of his other guys. I don't recall their names, but
And were you present during that inspection?
I was present, yes.
Okay. Did you and the HREP individuals have any issues accessing the building on the 9th?
We did. When we showed up at 7:30, the gate was closed and no lights were on. It looked like nobody was at the property.
How long did you end up having to wait to get in?
We just stood out on the road talking outside the cars for about 20 minutes and figured out it was going to be thought it would be a no-show. And one of the gentlemen walked over to the gate that was pulled together and saw that it was unlocked and the chains were off of it. And they said, well, since we're here, do you mind if we just walk around the property? And I said, no, I don't mind. We had an appointment signed. Let's just, so they pulled open the gate and they walked inside. I stood out, I believe with TJ, just at the gate area. And then they yelled up at us that, hey, son, it looks like somebody is in here. So we finally found someone was actually in the building. The building was open.
And who was in the building?
Ed was in the building.
Mr. Smith. Okay. So he had been sitting inside the building kind of in the dark
Did
the
not
whole
come out
time?
to meet us, did not turn any lights on or give us any indication he was there.
Okay. Can you describe Mr. Smith's behavior during the inspection once it started?
He was very removed and detached. He was obvious that he was uncomfortable and did not like what was going on. He stayed away from us, never came up and spoke, never shook my hand or said anything to that, and just basically stayed detached during the whole time. Very uncomfortable situation.
Why was it an uncomfortable situation, Mr. Dunn?
Well, because we did not really know what we were dealing with there. I mean, when you go to inspect a piece of property and the tenant's there, I really thought he would come out and speak to everyone and, you know, kind of be there while we were doing the inspection. But he just walked away.
And how long did the inspection last?
Oh, we were probably there. I was probably there an hour and a half or two.
So during this initial period where you're trying to schedule the inspection up through getting the inspection done on December 9th, did you ever speak with Mr. Smith regarding VBT potentially continuing on as a tenant with Hickory as the owner of the property?
I had expressed to him many times that they wanted to retain him as a tenant up before that. By that time, communications obviously were not going very well between he and me.
Did you try to arrange for any discussions between the two parties?
Yes, yes. I thought both of them, they should reach out to each other and have some kind of conversation. And I thought that inspection would be a perfect time for them to develop some type of relationship so they could negotiate.
And it sounds like that didn't happen on
That
December
did not happen.
To your knowledge, did VBT or Mr. Smith, through Mr. Smith, ever take you up on your offer to have a discussion about an extended lease with HREP?
Not to my knowledge.
All right, so did there come a time, Mr. Dunn, when Hickory requested an extension on the inspection period?
Yes, they asked me for a 2-week inspection, or 2-week extension of the inspection period. They wanted to send, I believe, some other people there to do additional inspections. That's what I understood at the time.
Okay. And why did they need that 2-week extension?
That is a good question that I'm not really sure of. They just weren't able to finish all the inspections and be comfortable enough
To
with
your
the
knowledge.
property, to my knowledge.
So this is, you mentioned you were there for almost 2 hours that Saturday morning. This would have been more inspection beyond that.
That's the way I believe it, yes.
Okay.
Did you agree to that 2-week extension?
I did agree to it, yes.
So after granting this kind of 2-week extension, did there come a time when Hickory demanded you sign an amendment to the sales agreement?
Yes, it did. They did.
What was the purpose of that amendment?
They wanted to change the original contract so that they could purchase the property subject to the lease. And that they basically wanted to agree that whenever I was able to sell the property, that I would end up selling it to them. So if it was extended, the purchase date was extended, it did it out.
You said, I missed what you said about the lease.
He said,
Subject to the lease.
Subject to the lease.
They decided at that time they wanted me to deliver the property without a tenant in it,
Without the tenant in it?
without the tenant in it.
Okay,
so not subject to the
so
lease.
not subject.
Not subject to the lease. Sorry, I missed.
That's okay. I just want to make sure I follow. So the original negotiations were, Mr. Dunn, we'd like your property and your tenant. Then things changed, and when they asked for the amendment to the CSA, it was to say, we want it with no tenant.
Correct.
Okay. And did you sign an amended CSA, or how did that work?
An amendment to the CSA.
Okay.
I am marking as defendant's exhibit
Okay.
5, Your Honor.
Thank you.
Can you take a look at this document, Mr. Dunn?
Yes, this is the First Amendment to the commercial sales agreement.
Okay, and this is an accurate copy of the First Amendment that you ended up signing?
This is a, yes, it is.
Okay, move to admit exhibit 5, Your Honor.
Any objection to this document?
No objection.
Admit it. Were there other amendments, or is this the only amendment?
This is the only amendment, Your
Okay.
Honor. This is the last, or the only. Now, Mr. Dunn, did you have an understanding as to what would happen with respect to this deal with HREP if you didn't sign this sales agreement, this First Amendment?
Yes, I had a very clear understanding of what would happen.
And what was that understanding?
They would sue me for breach
Okay, and what would, for not delivering the property?
as a commercial sales agreement state.
Okay. What's the current status? Well, first, can you go ahead and remind, I know Judge McBurney is taking very good notes, but can you go ahead and remind the court when the lease with VBT expired?
March of 2024.
March of 2024. And did VBT leave the property on March 1st of 2024?
They did not.
Is VBT still in possession of the property today?
They are.
have you pursued legal action to evict or eject VBT?
Yes, Your Honor.
That's the Clayton County case I've heard a little bit about.
Correct.
Okay, what's your understanding of the status of that?
We got the writ to remove him, and he has appealed.
Okay.
So your testimony, the sale to A-Trip, that was supposed to close on February 5th of 2024, is that correct?
That is correct.
Right, and has that sale closed?
It has not.
So as you sit here today, and as we're in the courtroom today, you haven't received your bargain for proceeds from that sale?
I have not.
And how much were you supposed to receive at closing?
The sales price was $960,000, and then net from commission, I would have gotten about $912,000.
And what was your expectation when you entered the sales agreement with A-Trep regarding receiving those $912,000?
I would receive those funds at closing.
Okay, and that closing date would have been February 5th of 24?
Correct.
What did you intend to do with that $912,000 when you received it, Mr. Dunn?
I would have put it into my investment accounts and spread it over my growth portfolios.
Okay. So in the last 5 or so years, have you sold any other businesses? Otherwise, I believe you mentioned selling one of your bus sales businesses.
Yes, I have. I sold my bus dealerships, as I mentioned, in August of 21. I've also owned a number of other pieces of real estate, and I've sold a few other pieces of real estate during that same time period.
Okay. And as a result of selling those other businesses and pieces of real estate, I'm assuming, received cash in exchange for those properties?
I did, thank goodness, yes. I have.
And what did you do when you received the cash from the sale of your business?
Pay taxes first, and then invested in my accounts, my investment accounts.
Okay, your investment accounts. And what did you do? I believe you said you sold also a piece of real estate.
Piece of real estate, yes.
Yeah. And what did you do with those cash proceeds?
I invested those into my portfolio, and did the same thing with those. Thank goodness the market has been performing. Yes.
So it sounds to me like you have a bit of an established plan for when you get these kind of major cash out events from these sales. Is that correct?
I do. I have a strategy that I followed every time.
Okay. That's a strategy that you do in conjunction with your
With my advisor, yeah.
Okay.
What part of this is more of a question for you, Mr. Ryan. What part of the First Amendment strikes the language that says we're purchasing subject to lease, or we're okay having a tenant? I'm trying to, it has a bunch of sections that say delete this, delete that, but I'm tell you
Yes.
the substance of what's being deleted.
Yes. Section 2 of the First Amendment, which deletes section.
The first sentence of section 4.
Wait, no. It doesn't actually line up here. Hold on.
Yeah, that's right, because they're conveying it subject to the rights of the tenants under the lease, and so they want that gone. In other words,
I'm looking at the wrong.
they want to buy it.
I'm
Okay.
looking at the- Yeah.
Got it. Okay.
So why has this kind of been your plan of attack for these cash events as you're winding down your business?
As I mentioned earlier, it was to simplify my life and my estate and prepare for my family if anything were to happen to me.
So I guess your plan for the cash you would have received from the A-Shrep sale on February 5th of 2024, was that consistent with kind of this standard operating procedure?
Yes, is what I'd done before.
Okay.
That's what we've been planned.
So you mentioned you put you were going to plan to put these funds in your investment accounts. You currently have some growth investment accounts, is that correct?
I do.
And have you received kind of returns from those investments since February 5th of 2024?
I have.
Okay. And what have those kind of returns been on an annualized basis?
Well, I calculate them, they're about 20% a year on an annualized basis.
And do you receive reporting from your broker regarding those returns?
I did. I asked him to run an analysis for me.
And what does that kind of analysis or portfolio analysis look like?
There are 4 funds that we reviewed, 4 funds that I own, where the funds would have most likely gone, and he calculated it from that time period of 24 till today and what the returns would have been.
Okay. I'm marking exhibit number 6.
Thank you.
Is this what's been marked as exhibit 6? Is this the kind of portfolio review report that you were just discussing?
It is.
Okay. Now I note that there are some redactions on here, and I'll in all candor, what's been redacted, Your Honor, or everything but the last 4 of the account numbers, standard procedure, and then the market value and total assets that are reflected at various points throughout this document. Since that our position is the Mr. Dunn's net worth and the value of his investments that existed are not relevant. What is relevant are the rates of returns that are reflected on this document. So given that explanation and Mr. Dunn's testimony, I would move to admit exhibit 6.
Objection to relevance, Your Honor. These particular damages are not connected to their cause of action. Their cause of action is my client caused some sort of interference with their first contract, and therefore collaterally somehow his portfolio is harmed. That's not related to the first contract. There's no proximate connection there. And he still has the second contract. So I'm going to object to relevance. It does not pertain to their cause of action. It's not a damage.
If things had gone as planned, I'm playing out what I think that Mr. Ryan's argument is going to be, which is why I think this is relevant. If, I'm not saying this is what happened, but if your client had not interfered tortiously with the contractual relations between Dunn and HREP, then Mr. Dunn would have netted $912,000 in early 2024. And this document helps us understand. He went on to testify, and I plow it into my Merrill Lynch account. This is the Merrill Lynch account. And I agree with Mr. Ryan. The amounts in there don't matter. It's how well has that done, because this is the opportunity cost that Mr. Dunn has experienced because, again, I'm not making this finding, but the argument would be because Mr. Smith interfered with Mr. Dunn's contractual arrangements with HREP, he was unable to plow $912,000 into a portfolio that from January 24 until now has grown at X%. How else do you back into a figure? If I'm a juror, I'm like, well, what did he lose? He lost the ability. What would you have done with the 912? I put it in a sock. Okay, I know what your damages are then. But he doesn't. He's testified, Mr. Dunn, that he puts it in his Merrill Lynch account. And this shows us how it would have grown from January of 24 through today. That seems relevant to damages. What am I missing if that's Mr. Ryan's argument? And that needs to be his argument, I guess, if he wants this to come in.
Right.
It is my argument.
So the issue isn't right, is what it is, because they built into this amendment growth. So they have an additional $28,000 coming in per year on this contract.
Meaning the sales price.
Yeah.
Yes, I saw that. And so we need to navigate that because a delay in the sale nets Mr. Dunn more and more and more. In fact, it's over $1 million on through the end of this year. They're not even outside that window yet.
Exactly, Your Honor. So it's not a right argument yet. Essentially what they're going to get is double recovery when this does ripen. So they cannot prove those damages. They're only speculative. I don't think a jury can navigate it. I know I can't, not right now.
But wouldn't the math I would need to do be the 912 would have grown by X, whatever that math is, but then I should subtract from that, to your point, but what would Mr. Dunn have earned had the sale gone through? He gets a benefit. There's inflation to the contract. And so if the property is sold at $1 million, he actually made more because that price went up. And shouldn't I back out that from the missed investment opportunity so there's not double recovery?
Great questions. And the issue is this, we're getting into speculative damages for 3 reasons. One, the portfolio is only speculative. You can say he would have done that with money. He may have put the money elsewhere. We have no idea what he would have done with the money too.
Well, except he just told us, we're not speculating. Mr. Dunn has said under oath, like I did with my other sales proceeds from properties, I would have put it in my Merrill account.
Okay.
So that's not speculation.
I'll cross-examine him on that.
You will.
issue. I get that. The other 2 issues is, one, he's still getting rent. He's not getting rent from the guy who he's claiming interfered with all of this. So that's a continuing moneymaker.
But that's an argument you'll make in terms of, Judge, when you're doing this math, you need to back out rental income. I think you made another good point with and look, he's going to sell it for more, this 912. I mean, that there's this price increase built into the contract. But I still don't see why Mr. Ryan isn't entitled to argue, and what is the foregone opportunity cost? Had this deal gone through, if the evidence is the only reason it didn't, and we're about to hear from the 2 Hickory people, and they will tell us, I suspect, the only reason it didn't is because we got creeped out by what was going on with VB. We weren't comfortable with that situation. And so he needed to be off the property before we would buy. He's not off the property, and tick, 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 the money's not in this account that's growing at, not speculatively, but we know the rate of return. I'm making the number up for right now, but it's up 20% from January of 24. I suspect it's more than that, but if it's that, then he missed out on that. You got to back out that, but he's earned some rent and he's going to be able to sell it for more, but there's still that missed opportunity to which he was entitled if I find that your client intentionally and tortiously interfered with that deal.
I understand everything you're saying, Your Honor.
Okay.
I'll just prepare to cross-examine him.
Okay.
for those issues.
But I appreciate you flagging it. I'll admit this, but you're going to need to navigate a little bit because the numbers bounce around a lot on the rate of return.
They do, Your Honor.
Okay.
All right, so let's take a look at this portfolio review document. There are 4 accounts listed on here.
Yes.
Why did you choose these 4 accounts?
Those are accounts I've owned for many, many years and have performed well for me over the years and the ones I'm most comfortable with for growth.
Would these have been the accounts you would have deposited the proceeds from the A-strip sale into?
Yes, that would have been my intention, yes.
Okay.
Are these names that you gave to the accounts, like Davis Large Value and Custom Strategy, or is that a Merrill product?
They are all Merrill Blended Management Group products. Yes.
So, assuming I had enough money, I could invest in Custom Strategy or Capital Group, or is this unique to Mr. Dunn?
No, you could invest in those funds.
Okay,
Yes.
Given these returns, I know where my next $11 is going.
They do have a minimum.
Oh, well, see, privilege.
And what was your intent? Were you how are you going to split the money up between these 4 accounts?
I would probably have split it equally across the 4 accounts at the time.
Okay. So if we look at the pages starting on page 4, there appear to be some, well, one, it says performance period across the top. So what is the period that this is covering?
From February 1st, 24 to February 20th of 26.
And it looks like there are some bold lines here. In fact, 4 bolded lines, and what do those bolded lines represent?
I'm sorry, I don't know what you're talking about. Everything.
Sorry, there are, so if you'll look at it's redacted, so it's hard to kind of see, but they're at the top of the page.
Do you have
below the
this
black.
digitally? Because another thing you could do is put it up on the screen. I don't mean to throw a curveball. Look, you guys are not in Zoom right now. You'd have to be in Zoom. If you think you can, you're welcome to go up to the stand and say, what's this right here? But with everything redacted, every line looks bold.
Mm-hmm.
Fair enough.
Thank you.
So I will indicate to opposing counsel what I'm going to point out to first. If you have the exhibit, it's these lines that are bold as opposed to.
Blue lines?
Yeah, bold lines.
Gotcha.
Okay. So I'll just approach briefly.
Sure.
Mr. Dunn, I'm seeing, say, at the top of this page 4, there's the last four digits of the account number and then the name equity income.
That's correct.
And I see that as being in a bold typeface.
Mm-hmm. Oh,
And then that
that's
line
what you mean.
continues to cut across, and it has a
Cumulative rate of return.
cumulative rate of return at the end.
Correct.
And then that kind of bolding next to the various account rates occurs a couple times. So there's equity income on that top line I see. At the bottom of this page 4, I see one titled Capital Group.
Capital Group, yep.
And then on page 5, towards the bottom of the page, there's one for Custom Strategy.
Strategy, yes.
And then on the last page, there is one titled Davis Large Value. Is that correct?
Yes.
Okay.
You need to
On
ditch
page
that
6, page
custom
6.
strategy. It's not doing as well. Yeah.
So what do these, so if you look over on the rightmost column titled ROR CUM percentage, what does that column reflect?
That is a cumulative rate of return over that time period.
Okay, so is it correct to say that the equity income account returned 47.24% between February 1 of 24 and February 20 of 26?
That is correct.
Okay. Likewise for Capital Group, that was a 40.12%
Correct.
return?
Yes.
So this is nothing annualized. It says, you rarely see figures like this. But
Correct.
what it says is, as I'm understanding it, if I had invested $1 in the equity income portfolio on February 1, 24, about the time of the closing, I would have actually $1.47 in the end of February 26.
Correct.
It might be up and down because there were some negative rates of return in there for the period, the monthly period. But in the end, my $1 would be almost $1.50, or my $10 million would be almost $15 million.
Right.
Okay,
Or my $1 million would be 1.4.
whatever the blacked out numbers are.
Right. Okay, so how would kind of taking those numbers, how would you get kind of the average rate of return for these 4 accounts?
You would blend them all together.
Okay, and
Yes.
just create an average.
Create an
Simple
average, yes.
formula, and that would give you the average rate of return for this time period.
Correct.
Okay, and have you done the calculation to annualize that return?
I have.
Okay, and what is that annual rate
It's,
of return?
I believe it's 19.8%, a little less than 20%
And
annually.
now I'll represent just an argument, since it's in the record, that that's been about 757 days since between the February 5th closing date and today. What approximately is the earnings? Would the earnings have been on that $912,000 over that time period at that rate of return?
Approximately 375,000.
I need that figure again.
What would have been the total return over
Dollar-
that time period?
The dollar in dollars?
In dollars, yes, sir.
Yes, about $375,000.
So if 912 had been in there, had you been able to plow those proceeds in, you would have earned 375,000.
That is correct.
And that's that sort of 20-ish%
Annually.
annually.
Over the 757-day period.
Okay.
Mr. Dunn, have you incurred any other costs related to the fact that you still own the Lee's Mill property?
Yes, I continue to incur costs with property taxes and insurance.
Okay. We're exactly.
Okay.
I want to quickly run through a few exhibits. I'm marking exhibit 7.
Know what that looks like?
Mr. Dunn, can you tell the court what exhibit 7 is?
This is the property tax statement from Clayton County.
And is this a true and accurate copy of your, and from what year is it?
2024.
Okay, and this is an accurate copy of that tax statement?
It is.
Move to admit exhibit 7, Your Honor.
Any objection to 7?
No,
And so what were the property taxes that you paid in 2024 as from owning this property to Clayton County?
$4,882.74.
Okay. And are you claiming the full amount of those taxes here today?
I am.
You are. Okay.
Yeah.
Okay, exhibit 8. Then about exhibit 8. Similar document. Can you please go ahead and describe what that is?
This is the property tax statement from December of 25
Okay, from Clayton County as well,
from Clayton County as well.
for the Leeds Mills property.
For Lease Mill.
And this is a true and accurate copy.
It is.
Move to admit exhibit 8, Your Honor.
Any objection?
no,
Also admitted.
And what are the total taxes for 2025 for the property?
$6,463.17.
That was a big increase.
Yeah.
Do you have you estimated property taxes that you've accrued thus far through 2026?
I have.
And how have you done that?
Just took the number of days so far into the taxable year and estimated what it would be and the taxes would be and calculated what's due at this time.
And what did you use as kind of the estimate for your 26 taxes?
So far to date, or the same amount as what I used.
Same amount as your 25 taxes?
Yes.
Okay. And what would that dollar value be? with that
Approximately
calculation?
$1,000.
What?
Approximately $1,000.
Okay. All right. Now you also mentioned some insurance costs. I've marked as exhibit 9 document here. Can you go ahead and repeat that document real quick?
Thank you.
Yes, it's the insurance bill from the insurance agency in Fayetteville that I insure the property with.
Okay. And is this for property insurance?
Property insurance, correct.
Okay. And what year is this for?
24.
And what, go ahead and move to, this is a true and accurate copy of your invoice.
It is.
And it looks like there's a second page. What is that second page?
My check
Check for paying
for
costs?
payment, yes.
Okay. Move to admit exhibit 9, Your Honor.
no objections, Your Honor.
Admitted.
Okay, and what were your insurance costs for 2024?
$3,308.24.
Thank you.
So, I don't know how these exhibits will be made into a record, but the check has Mr. Dunn's account number on it.
Oh, it
It's not
doesn't.
redacted.
When we,
I'm not going to write it down, but
Yeah.
just as you're working with the court reporter and he's pulling together the record, you might not want the unredacted check.
you are correct, and that was missed, Your Honor.
Up to
Thank
you. It's your client.
We will, when we submit them to the court reporter with opposing counsel's on objection, redact all but the last 4.
Okay.
When we submit those to the court reporter.
Okay.
Okay, so you mentioned you also had a 2025 insurance payment, is that correct?
Yes.
Marking exhibit 10. Now, exhibit 10 is a bit of a different document. Here, Mr. Dunn, can you describe what exhibit 10 is?
Yes, it also has my account numbers on it. Yes, it's the payment for the insurance for this year.
Okay, there isn't an invoice attached to this exhibit, is there?
There's
reason why?
not. There's not.
And why is that?
I was unable to retain one. I could not locate it. I called the agency and this is all she could send me back, but she assured me that I have the policy, which we didn't print out. Yes.
And so does
Didn't have an
this,
invoice.
does this check here, it looks like it even has something in the memo line. What are those numbers? PAV 04?
That's the policy
That's the
number.
policy number?
Correct.
Okay.
And that matches with defendant's 9. Well, it's less. Your insurance went
Oh,
down.
went down. Go for it.
Taxes up, insurance down.
Yep. Move to admit number 10, Your Honor.
Any objection to the check? Okay.
And then to short circuit, marking 11, I believe Mr. Dunn will identify. You can go ahead and check on that.
Yes, this is the policy, again, from Penn,
And what year is this for?
2026 through
Okay.
2027.
And this is the property insurance policy for the Lee's Mill property?
It is.
Okay. And it looks like the premium went down again. What was the premium for 2026?
$2,930.72.
Okay. Move to admit Exhibit 11, Your Honor.
No objection, John.
Admitted.
So we had a bit of a council discussion on this one already. So in fairness, we've talked about what you missed out on and what costs you've had to incur as a result of retaining the property. Have you received, I don't know that I want to call it benefit, but have you received any benefit from the fact that the sale did not close on February 5th of 2024?
I've continued to receive rent below market.
Okay. You mentioned below market. What do you mean when you say that?
The rent that VBT has been paying me is the rent from the last year of the lease. And obviously the property has greatly increased since then. So since my lease would have expired in 24, I could have started charging more rent thereafter that.
But I guess, so in the interim, you've received, I guess
5 months and yeah.
what, 25 months in
I've
rent?
received 25 months or $7,000 a month.
Okay.
$175,000 total.
This is from VBT as a holdover tenant?
Yes.
Okay. And so what are those 25 months worth of rent come to?
I believe $175,000.
Okay. So you've received $175,000 as a result of VBT not vacating the property?
Yes, well, you know I haven't received
Well,
it yet. But
you've
yes,
received some of it and some of it is still in the registry
some of
report,
it,
correct?
Yes, correct.
Okay.
So at some point, probably in connection with the litigation about the dispossessory action, VBT began paying rent pursuant to the old contract, so below market from your perspective, but into the registry because there was this legal contest about occupancy and possession.
Correct.
Okay. But as far as you know, it continues to be paid in. So I think if it doesn't, you get the land.
As far as I know.
Okay.
it has.
All right.
All right. And then in looking back at the First Amendment, which I believe was Exhibit 5, there was some reference to a price escalation in the First Amendment,
Yes,
depending on the closing date. Is that correct?
that is correct.
Okay. And so what did well, I guess, one, we don't know what the final price may or may not be.
Or if it'll close, yes. Yes.
But as of this point in 2026, what is the agreed upon purchase price for the property?
It went up from 960, I believe, to 988, and then ends up where it is now. It's $1,018,000.
Okay. And so if or when the sale to Hickory closes this year, about how much more would you receive based on the timing of the closing under the First Amendment to the contract?
From the 960 to the 18,
Yeah.
whatever, the $58,000.
Sure. Would that maybe be adjusted a little bit given the different commission rate that you would pay on the larger value?
That is correct, yes, sir.
So somewhere in the $55,000 to $58,000 range.
Yes.
Okay. And I guess my last question for you, and kind of walking through these damages, have you incurred attorney's fees in prosecuting these claims just for the tortious interference counterclaims?
I have.
You have. Okay. 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 Very good. And you're claiming those attorney's fees today?
Yes.
Okay. All right. I am done with Mr. Dunn for now.
All right, Mr. McMaster, if you have questions of Mr. Dunn, now is the time in connection with the counterclaims.
Ron?
Yes, sir.
Bio break.
We sure can. I'm going to give you a moment to prepare. Mr. Dunn's asking for a quick break to hit the restroom, so we'll do that. I will be back out here in just a moment.
And Mr. Dunn, you're still on the road, so. Okay.
You are, and don't interact with Mr. Ryan.
Oh, okay.
The equipment working?
What's that?
Equipment's working?
Yeah, everything's good.
Good.
Good card.
We'll go ahead and the card, we'll email you directly the exhibits.
I do not have a card.
Okay.
I can give you one.
Okay.
They have these digital cards and I can just get you off my
Fair enough.
It's Austin Legal Productions Gmail.
AUSTIN.
Yes, sir.
Okay. Legal Productions.
Production things.
Just at Gmail.
Yes, sir.
Okay. And what?
Productions with this.
S. Yeah.
Thank you.
And you are Austin.
Yes, sir.
Forgive me for asking.
Oh, no, you're good. We all. Yeah.
What? Sure. Sure. I didn't have to. Which has kind of been part of the course in this case.
No, trial.
The one you're saying, yeah, you know.
Yeah. The only note I have was the Merrill Lynch document, exhibit 6 actually needed.
I believe he did, but I will confirm when he
Yeah,
comes back.
that's the only one I have. The rest I.
Okay, great.
Thank you. Any other observations?
What?
I haven't eaten anything at all and didn't bring anything. So I didn't think I would be here this long.
Are you begging for food?
Protein bar?
Yes. I thought I would leave, I thought I was gonna have like a 2-hour break
Yeah,
and I was gonna go to a cafe.
well,
So that's
Blaze
what I-
and then family law, right?
That's what I did for thinking. What?
Okay. A little bit longer.
About an hour.
What?
About an hour.
Yeah, that's not bad.
No, it's not.
The world burning line. Grinders.
I appreciate you, Luke. Yeah, it's good, man, any day. Every time we're going around, it's good. You gotta work. I want I love come in. That's your whole. No, they ain't got this, they ain't got that.
I didn't want to bring fireworks.
I don't bring snacks, thank you.
What?
I was saying, I don't know why I don't bring snacks, thank you.
Oh, you're very welcome.
So dumb.
You got so many cords.
Yeah, that's well, that is one thing. You know, I can't get too fast.
Yeah.
Do you have the four copies of
Sometimes
these?
a cafe will have.
Yes.
The front.
Not that one too.
Oh, yeah?
You just-
I just-
you
I did not
didn't
grab
have
it. That's why I'm looking at,
You
I'm looking at
I
the,
just
looking at the lease.
I'm like that.
Wait, what?
I noticed that. You were too focused to distract.
At the very least, I'm encouraged.
Get to do that every day.
Yeah.
You know, but.
5 years, I know that, but I
I'm
just.
encouraged at the very least. Yes.
Yeah. I think it's just what he would have done.
What?
I said, I think that's just what he would have done. He was explaining it.
Oh, in terms of like trying to split it?
Yeah.
I'm very, very encouraged.
Yeah, I am too.
Oh, email.
Three is.
It's the email, the notice email.
I don't have it in here. So you must have it.
Yeah. It's a rock. So I don't hate the case. I saw a little bit, but I hate these attorneys. They're just ridiculous individuals.
That's Where you want to go, sorry? Well, yes.
I haven't touched it yet.
Yeah, I don't think I can turn it off either, but that's good. Maybe it's, I don't know if it's this, but it's fine.
It sounds like someone trying to work phones. That,
Oh,
that's not me doing anything.
yeah. I will use this. I'm gonna take.
I think it is that mic and it's just not good.
Well, this one.
Then alert.
Oh, was that one? Oh, it was one of them. I've seen y'all mess around with them enough, but I didn't know quite enough how to fix it. Yeah. What's my master, what's your from me?
Matthew D. McMaster, LLC.
Okay.
To figure out what that means.
Those are all.
Yeah,
Okay.
based on the, I can pull it out, but based on like actual total. And
Okay. Great. And then the numbers are correct. I was preparing for fees first, so I will. Pretty true, but it's where I'm using it. 36 of this thing.
okay,
Yep.
do you want me to ask them?
I mean, you can. Lord. I think you can.
Yeah, I'm not gonna use that
I don't even. Oh, the timeline email. I'll give you it.
email. No, it's gonna go here. So.
Yeah, don't worry about it. I agree. It's a good call. No. You don't need to introduce it, but if you need to show it to him, you can show him, you can have him with the.
You just.
Kind of, but you don't look at it.
Okay.
Do you recognize it? Is that true? Just so you get double confirmation. It's already edited, but just so you last time you get correctly wrong. Got it. That's what I did. Yeah. I think that'd be fine. Don't have script once. You have an off script once. Think about it first. Which you can explain it. I think that's right. Yeah, for sure. Yeah. That's the thing. Like that in your office. When you're not gonna tell her. Yeah, I'm not weird. Listen.
When this meeting, tragedy.
In my courthouse, we're gonna speak of that.
Council, did you send those or were you gonna wait till the end?
We'll wait to the end.
Okay, I just want to make sure I was. If you can go on this one.
Yeah.
We should.
Should I ask them to take this?
What?
Can you see the book on the wall?
He said remain seated. I think that's what Deputy Gordon said. He did. Okay, all right. But thank you. We are ready now for cross-examination of Mr. Dunn. When you're ready, Mr. McMaster.
May it please the court, Matthew McMaster here for the plaintiff, cross-examining Mr. Dunn, the defendant. Mr. Dunn, turning to your CSA, your commercial sales agreement, do you have a copy in front of you?
I do.
Right. Go to paragraph 5 for the court, please.
All right.
Mr. Dunn, that paragraph talks about a lease, and the lease that it's discussing attached to this agreement as an exhibit is the lease with VBT, is that correct?
That is correct.
Okay. Okay, and then going to, I believe it's Defendant's Exhibit 3. This is where you sent an email to Ed, and Ed is Mr. Smith, correct?
Correct,
And he's the owner of VBT, to your knowledge?
to my knowledge.
Okay, and he's the one who signed the lease that you have, correct?
Correct.
Okay. You sent him an email on November 17th, and that comes in as your Exhibit 3. And you say, Ed, I want to let you know I have entered into a sales agreement on the building. When you are talking about the building, are you referring to building that VBT is renting from you or leasing from you?
That is correct.
Okay. And why did you want to let him know you entered into a sales agreement?
Because we have to come and do an inspection.
Okay, and he was the occupier at the time?
He was the tenant, yes.
Okay. So he was a tenant on November 17th, 2023. Was he in lawful possession at that time of the property?
He was my tenant, yes.
Okay.
Yes.
Okay, looking at your Exhibit 6, your annual performance portfolio review.
Yes, sir.
How often did you share your portfolio and its performance with Mr. Smith or any agent of VBT?
I never shared any performance of my accounts with VBT.
When was he notified that you had this portfolio?
I don't know that he ever was.
You still own the property, correct? The property in question?
Correct.
Okay, I'm going to share with you a text message. And I'm going to get a copy for the bench. Did you print the exhibits I gave you?
I did not. You have a copy, I'll take it. If not,
Okay, it's my Exhibit 6. Your Honor, I'd like to tender you a copy of this so you can see it.
Okay, this is plaintiff 6.
It is, yes, it's plaintiff's 6. Are we going to keep the numbers that I emailed the staff? Or as they come in?
It really depends. If there's already a 6 on it, then we should call it 6. If there's not a 6, you can call it whatever you want.
Okay, I'll call it P1 because there is not a 6, there's just a cover on it. I'm good
Okay.
with that.
Cover's gone. Do you have a sticker or you're going to handwrite? As long as the original, which will be what you give to Mr. Dunn and ultimately goes to the court reporter, you can handwrite on mine, however you want to do that.
Okay, great. Thank you, Your Honor. I'll go ahead and put a sticker on everybody's.
Okay?
It will be plaintiff's Exhibit 1, but I got to get it admitted in first.
Okay. And you've got a copy, Mr. Ryan?
I do.
Okay, great. Please. Thank you.
I didn't get you a copy.
No, sir.
I'll survive. Okay. Go and have a look at that. Do you recognize that document, Mr. Dunn?
Yes, I believe it's part of our message chain.
Okay. You don't dispute that this text message chain actually occurred between you and Mr. Smith, do you?
No, I have no reason to.
Okay. And so on December 16th, 2021, at the bottom, you say, "Hi, Ed, you in the office tomorrow? Thought maybe I could swing by and pick up the rent checks and discuss the purchase option extension. I could mid-morning or early afternoon. Let me know." Did you text that to Mr. Smith?
objection, relevance.
What's the relevance of, this is 2 years earlier, and I think we've already litigated this.
It's so he is aware,
He meaning,
Mr. Dunn, the relevance is, it's acknowledging Mr. Dunn knew that Mr. Smith had an interest in an extension of the option, not whether one happened and not whether they agreed to one, but whether or not he knew of Mr. Smith's interest of an option extension.
okay, and how is it relevant that he knew or didn't know that?
Great question, though, Your Honor. So we have, I just presented an email where Mr. Dunn says sorry, I didn't tell you about the agreement. So the point is, it goes to the fact that my client is not a stranger to the business in question. He's not a stranger to any of this. Everyone's aware of his interest, that he has, the interest that he potentially had. And so it's relevant. It's that stranger doctrine, Your Honor.
Okay, so you would rely on this to show that actually Mr. Smith, VBT, isn't a stranger to transactions surrounding the disposition of the land?
Correct. It's exactly, he's not a stranger to this, correct. He has an
Okay.
interest in it.
Mr. Ryan?
I don't see how an email from December of 2021 that occurred while Mr. Smith indisputably had a written option to purchase the property is relevant to show any interest 2 years later, or Mr. Dunn's knowledge of any interest 2 years later with respect to that Mr. Smith's or BBT's interest at that time to purchase the property.
Okay, I'm going to admit it. I hear your argument. I think it goes to the weight I ought to give something from 2 years prior. But I do think it's admissible in that space that Mr. McMaster is trying to move me to. So plaintiff's one, which is text exchange. Well, in particular, you're interested in that bottom text from Mr. Dunn to your client,
Yes, Your Honor.
is admitted.
And should I tender this to the court reporter?
So the one you give to Mr. Dunn is the official version. So he has one that says Exhibit 6. If you've got a sticker that says P1 on it, why don't you get that to Mr. Dunn and collect the one that says Exhibit 6, or however you want to label that. But we should get Exhibit 6 out of there because that'll confuse the record. You're welcome.
Yeah, look, P1 on your version, Mr. Don, I'll let you look at it and make sure that's, that's the document you authenticated.
It is.
Okay. I'm going to send those. What is it on this?
Four.
Okay, all right.
Is that up there?
Mr. Dunn, turning to your Exhibit 4 that your counsel handed you, and thank you. You state on November 20th, 2023, good afternoon, Ed. I had a great deal of thoughts over the weekend. Again, I am sorry I did not call prior to signing the sales contract. What were you apologizing for there, Mr. Dunn?
He had let me know after I sent the email notifying him that he was very disappointed that I was selling the property to someone else.
Okay. And why did you send him an email telling him you were selling the property?
Because I had sold it.
Well, had you sold it or you had entered into some agreement to?
Excuse me, correct, Your Honor. Yes, I had entered into a commercial sales agreement to
Okay.
sell the property.
But why would Mr. Smith care about that?
Mr. Smith was upset because he said he wanted to buy the property.
But why did you notify him you sold the property in the first place?
So we could go do an inspection.
Okay, I'm gonna turn to what I emailed the court as Exhibit 5, but I'm gonna call it P2. I'm gonna put a sticker on it, hand it to the defendant.
Mr. Master, is this the November 16th email from Brian Bratton?
And Your Honor, I presume you would like a hard copy, correct?
It would help. Please. Yeah, when you say hard copy, I have exhibits from Mr. Ryan. I don't have digital versions of yours. I don't know when you sent them to Ms. Niles. She's out this week, so if you sent them yesterday, she wouldn't have been able to forward them to me.
Correct, I was late on that and I apologize.
It's okay. So we'll need to work with the hard copies.
Yeah, first of all-
Please. So this is plaintiffs 2.
Yes, Your Honor.
Got it.
Okay, Mr. Dunn, I'm handing you what I'm calling plaintiff's exhibit 2. I'll have to look at that document there. There are 2 emails on this document. Do you recognize those emails?
It appears to be a email to me from Brian.
Okay,
Who is Brian Bratton?
He is
To
a
you.
broker for King Realty. He was actually HREP's broker, not mine.
Oh, and you mentioned that's how you learned about it, is that someone from King Realty reached out to you to say there's someone interested in your property.
That's correct.
Okay.
okay, and you say on November 15th to Brian, I have not shared any information with my tenant. Obviously, he is going to be concerned. You said that, correct?
That is correct.
And then you asked him, how do I handle this? Or excuse me, I'll be accurate. Any suggestions on how to handle?
Mm-hmm.
Does the purchaser want to state that they might want to keep them as a tenant and negotiate a new lease? You said that, correct?
Yes,
On November 15th, 2023.
yes,
And you had not signed the commercial sales agreement yet, correct?
I believe that's correct, yes.
Okay, and then you receive an email from Brian on November 16th, 2023. And it says, we're 100% open to discussing a renewal with the tenant, but we obviously can't make any promises. You recall this email?
I don't recall it, but I see it here, yes.
Do you have any reason to believe this is not an email that you have available to you?
No,
Okay, Your Honor, I'm going to move to admit plaintiff's exhibit 2.
Any objection to plaintiffs 2, Mr. Ryan? It's admitted.
Your Honor, I don't have further questions for this witness. Thank you.
All right, any redirect? It's okay if you don't.
No, I know, I'm just thinking. No, Your Honor.
Okay, Mr. Dunn, you can step down. Thank you. You should leave everything there. I'm gonna let the lawyers get that stuff organized and give it to the court reporter at the end of our session today, but thank you. Next witness.
Judge, we're gonna call Timothy Costin. He is in the hallway. Can we
Okay,
remember?
we'll get Mr. Ryan to go get him. Add some value. You taking my candy? All right.
Thank you for having me.
Yep.
Besides, are you questioning?
Yes. I'll switch the microphones for you before I get started. Does it matter which side it goes on? Can you hear me?
Do swear affirm the testimony you give is the truth, the whole truth, nothing but the truth, that's God. Lord, that's it. Can you state, spell your name for the record?
Need to,
J Costin. TJCOSTEN.
Mr. Costin, would you spell your full first name?
Timothy, TIMOTHY.
All right, Mr. Costin, we appreciate your patience this afternoon. Can you tell the court where you are currently employed?
Hickory Real Estate Partners, which is a company that I founded and am the president of.
And we have been referring to Hickory Real Estate Partners as HREP or Hickory. Is that all right with you?
So that's correct.
All right, you said you founded HREP. What else do you do at the company?
I oversee everything at the company, all operations, new investment decisions. Basically, I have my hand in everything.
And when did you start HREP?
Plus or minus 5 years ago.
What is the nature of HREP's business?
We are an entrepreneurial real estate investment and development firm. We're either buying raw land and developing it for new properties, or buying existing properties and owning them from there.
Is there a typical type of real property that HREP deals in?
We specialize in industrial, which is warehouses, maintenance facilities, trucking facilities, things of the like. And we specialize in undervalued, underutilized properties that we invest a significant amount of capital in, buy it, fix it up, get it into marketable condition.
Does HREP purchase properties subject to existing leases?
Yes.
And when HREP's looking at a transaction where there might be a tenant in the property, how does it handle that tenant's current possession?
The property is subject to the lease. So whatever the terms are laid out in the lease, we have to abide by.
So HREP will take the property subject to the lease if that's
Sometimes that's
required.
10 days, sometimes that's 10 years, depending on what the lease dictates, is the length of time, yes.
Does HREP ever work with existing tenants to renew or extend their lease?
Yes, frequently.
Right. Did HREP enter a contract to purchase 5845 Lee's Mill Road?
Yes,
And is that property the reason why we're all here today?
yes.
Would it be okay with you if we just refer to it as the property? Wonderful. All right. The commercial sales agreement should be on the podium. It's marked as Defendant's Exhibit 3?
No, 2.
2, excuse me. It should have a blue sticker, blue or greenish,
Yes.
and say 2. Do you see that?
Doesn't say 2, but I see.
does at the bottom. See that? There you go.
There we go.
Yep.
Do you recognize that document?
Yes.
And that's a true and accurate copy of the commercial sales agreement? All right. Who was the seller of the property?
Doug Dunn.
And was there a tenant occupying the property when you signed the CSA?
Yes.
Who was that tenant?
VBT LLC.
Are you aware of who VBT's principal is?
Yes.
And who is that?
Mr. Smith.
All right. What entity is identified as the purchaser under the CSA?
HREP Acquisitions LLC.
And is HREP Acquisitions LLC the same as HREP we've been referring to thus far?
Yes, yeah, it's a subsidiary of Hickory Real Estate Partners.
When was that CSA signed by HREP?
Off the top of my head, I believe it was November 15th, but I'm the signature page. Yeah, November 15th.
Of what year?
Excuse me,
Which year?
2023.
Okay, so November 2023 is when HREP signs the contract in this case. Does the CSA have an inspection period?
Yes,
And how many days was the inspection period for this case?
50 days.
Do you recall when the inspection period expired?
And you're free to look at the document. You don't have to remember it off the top of your head.
Yes, trying to do math in my head. Believe it was January 5th, I believe.
January 5th
I think that's right.
of 2024?
Of 2024, that's correct.
And did the commercial sales agreement have an outside closing date?
Yes.
And what was that outside closing date originally?
30 days thereafter, which would be February 5th or 6th
Of 2024?
of 2024, yes.
Following signing the CSA, what are kind of the next steps for HREP in a real estate acquisition?
The big food group would be to kind of get all the parties on the same page, everyone that's involved in the transaction from buyer, seller, tenant, all of the, relevant stakeholders. And then immediately, especially this is a very quick time period to get a transaction done. The first thing we're going to go do is have all of, our vendors and specialists to inspect the property, and run title, among other things that we'll do immediately, but.
When you say vendors and specialists, so it's not just you going in and kicking the tires and saying, this is some good land. What types of people are coming to check it out?
So our surveyor to start, to run a boundary survey and match that up with title, to make sure the property is what we believe it to be, in its dimensions and ownership record. Our environmental specialist, that comes in and says, hey, this is either environmentally hazardous or it is or it isn't. We'll have, various construction experts. We'll have a roofing consultant get up there, say, hey, is the roof caving in? Is it not? All of which I'm not, I've seen them a time or two, but I certainly couldn't diagnose it as well as they could. So a handful of other vendors from a construction perspective.
But all those people together constitute the inspection. It's not just you and other members of HREP looking at it. You bring in the expertise before you would say, great, we've inspected and we now are ready to ink the deal.
Exactly.
Okay.
All right, so all of that goes into the inspection. In this case, tell me about your experience trying to inspect the property.
Yes, we had just from the start, typically we are communicating. It depends on the situation, but frequently out of courtesy and out of ease, we frequently don't know the tenant or tenants at the property. So we'll communicate through the owner to set up our inspection. Right from the jump, we had a very difficult time scheduling any sort of inspection or reaching the tenant, to get out there. And it was evident that there were, putting up a bit of a roadblock for us to accomplish it in, a reasonable or short period of time. So it was about 2 weeks that we weren't able to make any contact, at that point in time, again, going through, the seller who was Doug, and eventually, made contact, and, tried to give notice to set up a time to schedule, to visit the property, to start making those inspections.
So when you talk about that roadblock, who put up that roadblock?
The tenant.
And when you talked about difficulty communicating, were you communicating through Mr. Dunn or directly with the tenant?
So, as is typical in a transaction, a broker, we're a buyer, we have relationships with brokers. A broker brought us the transaction, who was the intermediary between us, the buyer, and Doug, the seller. So we were communicating with the broker and with the seller.
Okay. Were you also communicating directly with the tenant in this case?
Not yet.
Okay.
But we
Eventually, did you?
very quick, as we started to have some movement and communication, and as we started running low on time, that's when we start communicating. We said, hey, the only way this is going to get done in any reasonable amount of time, and for us to maintain, what we were obligated to in the contract, was to communicate directly with the tenant.
Sure. As we get to the end of November 2023, were you able to visit the property for an inspection?
We got notice from the seller that he had been able to finally make contact with the tenant. And he said that, yes, we were able to go visit the property, to which we did on Monday, off the top of my head, but
Was it November 27th
November 27th.
of 2023?
Yes.
All right. Who intended?
Sorry, that was like two weeks after. Typically, it's the first thing that we are doing.
Gotcha.
So
Who attended that inspection with you on November 27th?
me, Chase Westfall, who works at Hickory, and Davis Maloof, who also works at Hickory.
So this would not have been, not that you guys aren't experts, but no one who is testing the soil for contamination or this roof is solid. This is the initial, well, we're the investors. We want to make sure that this really is what we think it is.
I'm going to go out there and I'm going to say, well, the roof is falling in. We need to get a roofer. The HVAC is not working. We need to get an HVAC guy, but the fence looks fine, so we don't need a fence contractor.
Okay.
And then I can kind of, divide and conquer from there.
Prior to this inspection, had you ever met VBT's principal, Mr. Smith?
No.
All right. So when you arrive at the property on November 27th, tell me kind of what happens next.
Again, because we're aware of the nature of the situation, communication was not good. We had started to hear of the dispute that is surrounding this entire thing. We're pretty cautious, but walked onto the property. I kind of poked my head around the corner of the building, looked into the shop, looking for the principal, Mr. Smith. I didn't know what he looked like or what he'd be doing at the time. So tried not to barge right in, was at least our intention. Very quickly, Mr. Smith, came up to me, met me kind of like right at the entering the building, at the entrance of one of the larger doors that was open. We then, kind of walked around the corner to get out of sight from his employees, which, is something that we're very conscious of. We try to be sensitive of the fact that, of those situations.
Sure. So when you get around the corner of the building, then do you have a conversation with Mr. Smith?
Yes. Yeah. So I started talking to Mr. Smith, just kind of opening pleasantries of, hey, we shouldn't be here very long. We're just poking our head around. We try not to, cause a ruckus or bring any unnecessary attention to ourselves. Chase and Davis, both standing right behind me as I'm talking to him directly. Mr. Smith then quickly goes into, making the threats of, saying, hey, if you don't back away from this transaction, Doug's not going to, and if you don't, bad things are going to happen. And quote unquote, bad things are going to happen, and quote unquote, some things just aren't worth it.
All right, let's pause there. So Mr. Smith says that statement, bad things are going to happen to you.
Yes.
And that, as you described it, threat was tied to HREP continuing with the acquisition of the property.
Very clearly, yes.
Did you have a response to Mr. Smith after that was stated to you?
I started to, I've been threatened enough that I don't try to provoke people. But I don't remember exactly the response I had. I think I asked him if that was a threat, and to which he quickly said that it was not a threat. And from that point, I kind of just wanted to tiptoe my way back out of the conversation.
When Mr. Smith said that that wasn't a threat, how did you perceive that response?
It's to be a canned response when he, in my opinion, as my eyebrows raised quickly, he realized that he had made a threat and tried to kind of cover his tracks.
All right. Following that November 27th inspection, or let me back up. After this conversation ends, what do you do next?
We left the property and, made the seller aware, made Doug Dunn, aware that we weren't able to make our inspection, and we left the property.
Following this inspection, did you have any sort of understanding regarding when HREP would be able to inspect the property?
Not immediately, but we started, trying to arrange for another inspection.
Was HREP permitted to inspect the property during VBT's business hours?
No.
When were you able to schedule an inspection of the property?
We offered to have all of our vendors out on a weekend to try to accommodate the situation, to which we were able to figure out a time for everyone to be available.
And does your team typically work on the weekends?
No, nor do any of our vendors.
All right, so you were able to schedule an inspection on the weekend. Do you recall what date that was?
December 9th, I believe.
December 9th, 2023?
Yes.
And Mr. Smith had agreed to that date?
Yes.
Mr. Smith had agreed directly to you, or Mr. Dunn relayed to you, I've cleared this, and you can be there, or were someone from HREP interacting directly with Mr. Smith?
We had begun to interact with him at that point in time.
Okay.
Sort of text messages going back and forth.
Yep.
I think ultimately this was arranged and agreed to between Doug, Mr. Smith, and our broker.
Okay. And your broker is the King Realty Bratton?
Bratton.
Okay.
Yes. But we were actively communicating with him at that point in time.
All right, so December 9th, 2023, you get to the property. What time do you recall was the inspection set for?
We set it for 7 a.m. That was the time everyone could get out there.
All right, and who all attended that inspection?
Me, Chase Westfall, Davis Maloof, Doug was there, both Brian Bratton and his partner at King Industrial Realty, Steve Ratchford, our surveyor, our environmental consultant, and a construction consultant, as well as our construction manager.
Okay, so you've got a big group out there that time?
Out there to try to get it all done as quickly as we could and, get 50 days worth of work done in 2 hours.
Sure. When you guys get to the property that day, does Mr. Smith have the property ready for the inspection?
He was like an hour late, or 30 minutes to an hour. I couldn't say exactly, but we had to kind of stand there and wait around for a while.
And why did you have to wait on Mr. Smith to get there in order to inspect the property?
To let us into the building. Yeah.
Was it to the building or to the gated area of that property?
I don't remember specifically.
All right, about how long was the inspection on December 9th?
It was about 2 or 3 hours.
And did you see Mr. Smith during that inspection?
Yes. Yeah, he had to let us in.
After he let you in, did you see him while the inspection was ongoing?
Yeah, he was pacing back and forth up and down the fence line, doing some, making some odd gestures and odd behavior in my, it appeared that he was talking to himself.
A little bit more about those gestures.
Yeah, he kind of, spent most of the time walking up and down the fence line and kind of gesturing, like tapping the fence, like as he's walking, like pretty methodically. And I believe he was talking to himself. I didn't see him, there was no one else around. And, very loudly making gestures towards the property and towards the fence and towards the property and kind of, and would have his head down and it's like pushing along the fence. And it was just extremely odd.
Was that behavior unusual from how you see tenants typically act
Very.
at an inspection?
Yes.
Was Mr. Smith helpful during that inspection?
He let us in.
Did you have any conversation with him besides, I guess, letting him you?
Maybe a
Him
word
letting
or
you
two
in?
in passing, but no conversation.
Okay. All right. Have you ever invited Mr. Smith to your office?
No.
So about 3 days after the December 9th inspection, do you become aware that Mr. Smith showed up at HREP's office?
Yes.
And was that December 12th, 2023?
Yes.
Did you have any prior notice that Mr. Smith would be at the HREP office that day?
No.
And were you at the HREP office at that time?
I was not.
Okay. How did you learn, if you weren't at the office, that Mr. Smith was at the office?
Everyone that was there reached out to me in some form or fashion immediately, with a lot of concern. They were very startled of the situation and frantically reached out to me to make me aware.
Is your office, HREP's offices, is it like going to a restaurant where it's clear the public comes and goes, or would it be like going to some accounting firm's fourth floor, it's a bunch of cubicles and yeah, someone could come visit, but basically because you're delivering something or?
It's a small office and yes, no one walks in, we don't interface with the public. Like we do not see people at our office.
Okay. This was atypical to have anyone other than I'm the FedEx guy showing up.
Very atypical, yes. I've never had a tenant show up to my office.
Which one of your employees or multiple employees called you or texted you that day to let you know that Mr. Smith was at the office?
It was everyone in some form or fashion. My secretary was very frightened. She's, a smaller woman in her mid-50s.
What is her name?
Dara Tab.
Okay. Who else?
John Michael Bush, who was there as well, who's the most senior person that was there at the time. And then Davis Malouf as well, texted me and Chase immediately. Chase was also not there. But he called me directly as well.
And what was your response to learning that Mr. Smith had showed up to the HREP office unannounced?
I was extremely concerned. I mean, he had threatened me a couple weeks prior and then shows up to my office, which is extremely atypical. I was very concerned. One, just of the situation, but two, that I was not there to try to diffuse it, try to protect my employees, whatever may be the case. But was extremely concerned, ultimately sent all my employees home.
Have you ever had a tenant in a commercial real estate transaction show up at the HREP office?
No.
And at the same time that you're getting all these calls from your employees on December the 9th of 2023, is Mr. Smith calling you?
Yes. Yeah. He called me several times amongst the tornado of communication that was going on at the time.
Eventually.
Meaning on this December 12th, you're getting pinged by all your staff saying, what's going on? And you're saying, during that time, Mr. Smith also reached out to you.
Yes.
At some point, well, let's start with, do you answer any of Mr. Smith's calls?
Not initially.
At some point, are you able to return his call?
I was able to return his call. Yeah. After I spoke with my employees.
And when you call him back, tell me about that conversation.
I got him back on the phone. I knew obviously what had happened. He had already spoken to Chase Westfall in my office, who I was in Las Vegas for a conference, which communication is difficult, also multiple hours behind. He knew that I was there, stepped up and called Mr. Smith. He had also, Chase had communicated with Mr. Smith in the past as it relates to our inspection and the purchase of the property, but called him and said, what the heck are you doing? That's completely inappropriate. He then called me. So I had, the lay of the land. I knew what had transpired, talked to Mr. Smith and said, we both know that's completely inappropriate. Don't ever show up to my office again. To which he responded something to the effect of, you did it to me. What's the difference in me doing that to you?
Pause there.
Sorry.
So the last statement in response to you telling Mr. Smith not to show up at your office to get that right is that he kind of said that's something that you had done to him.
Yes,
And what did you perceive that he was referring to when he said that?
when we made our inspection to the property.
All right, generally, was HREP able to complete its inspection-related activities by the January 5th, 2024 inspection date that we had talked about earlier? And why not?
We had, like I said, 2 hours to get 50 days worth of work in, and just wasn't adequate.
Did VBT's behavior through Mr. Smith impact HREP's ability to complete the inspection by January 5th?
Yes,
Did strike that. Did VBT's behavior through Mr. Smith impact HREP's ability to perform under the contract?
yes,
As a result of these inspection difficulties, did HREP and Mr. Dunn execute a First Amendment to the CSA?
yes,
And was that First Amendment as a result of Mr. Smith's behavior?
absolutely.
The initial closing date was February 5th, 2024. Was that right?
That's correct.
Did HREP close on the property by February 5th, 2024?
No.
Why not?
Given the volatility of the situation, it was not something that we were willing to insert ourselves into. And we felt that that amendment reflected
Under the first version of the CSA, was HREP taking the property subject to VBT's lease?
yes,
And did that change at all in the First Amendment to the CSA?
it to be delivered free and clear.
So one of the contractual differences between the CSA and the First Amendment is that now the seller, Mr. Dunn, has to deliver the property without VBT in it.
Correct.
I believe I said the tenant. When you had entered the CSA originally, HREP was willing to work with VBT regarding its continued possession.
Absolutely.
And we had discussed that that would be a common position for HREP to take.
Very common.
You got to speak up, lean into the microphone and speak up. Thanks.
Is it common for HREP to take the property with the tenant in possession?
Yes, very common.
Why did HREP change the language of the First Amendment to require Mr. Dunn to deliver the property without VBT there?
Given the volatility of the situation, it's just not something that a situation we were willing to accept.
And as we stand here today, has HREP closed on the property yet?
No.
Do you have anything? Mr. Costin, what do you mean by volatility?
The threats, the erratic behavior, showing up at my office, that's not a tenant. That is not behavior that I would like to associate myself with in a landlord and tenant relationship.
And did that behavior interfere with your contract with Mr. Dunn?
Yes.
Have you told Mr. Dunn, in effect, we're not closing until VBT is gone?
Yes.
No further questions.
Mr. McMaster, do you have questions for Mr. Costin?
Yes, Your Honor.
Yeah.
Okay, Mr. Costin, just a few questions here. The First Amendment to the Commercial Sales Agreement, the CSA, it's still in effect, correct? You still have a contract with the landlord?
Yes.
And in it, page one, I'm looking at it. I don't know if you have a copy of it in front of you.
Yeah.
You're looking at page 1 of the amendment or the main CSA?
The First Amendment, which is our only amendment, the amendment, Your Honor.
Yep, okay.
So if you look at paragraph one, subsections A, B, C, this contract contemplates a closing date as far out as December 31st, 2026. Is that correct?
That's correct.
Okay. And you said your company had been in communication with Mr. Smith?
At times, yes.
Okay, and your original contract actually had a copy of the lease attached to it, right? The original CSA?
We would attach that as an exhibit, yes.
Okay. So you'd agree that VBT had an interest in the property?
I believe they had lease term remaining. Yes.
Okay. You said you've never had a tenant show up to your office. Does that mean no one shows up to your office?
Very few people do it, but it would be, if people are coming to our office, it would be a scheduled meeting. So like show up, definitely not. But for characterizing that as unannounced.
Okay, and then when Mr. Smith came unannounced, did anyone call 911?
No.
Did anybody get a video of Mr. Smith and his erratic behavior?
No.
Does your office have cameras?
They do in the lobby.
Is there a receptionist desk in the lobby?
No.
You say as a result of Mr. Smith's behavior, you all amended the CSA. Why not open up a Merrill Lynch portfolio investment account instead?
I'm not sure what you're asking.
Why was amending the CSA the best use of your money?
The best use of my money?
Your
sorry.
company's money.
Yeah, I'm a real estate investor, not, we buy buildings or we build them. That is our business. I am not an, like Merrill Lynch, wealth advisor.
Okay, so you and your company and people dealing with the finances, you guys never discuss about, hey, let's put this money in a portfolio instead, investment with a bank?
No, we're real estate investors. That's all we do.
Okay, do you remember taking a deposition on February 20th, 2025?
Yes.
Okay, and in your deposition, just tell me if this is correct.
Objection, Your Honor. It's improper impeachment.
Well, I'm going to read a portion of the deposition and ask him if he said this.
So that would be improper. If you think there's something in the deposition that is inconsistent with what he's already testified to, you need to show him that. He can read it, and then you can ask him if that's different from what he said and to explain that difference, et cetera. But you don't get to get it before the fact finder in this setting.
Okay. I understand, Your Honor.
Okay. And if you are going to show him some things, if you just make sure you give page and line number sites so that Ms. Ith can be following along.
Yes, Your Honor, I'm okay, actually. They
Okay.
aren't that important to navigate all that. No further questions for this witness. Thank you.
Ms. Ith, do you have any redirect for Mr. Costin?
I have 2 quick questions.
She said 2. We'll see.
Mr. Costin, Mr. McMaster had mentioned kind of a Merrill Lynch account, and I want to clear this up. How much was the earnest money that HREP put down for this CSA?
50,000 off the top of my head.
Has HREP put any other funds down under the CSA?
No.
It's 2.
That was 2.
That's all I
right.
got.
Thank you. Mr. Costin, you can step down.
Thank you.
Next witness.
Yes, defendant calls Mr. Bush, John Michael Bush. We'll be ready.
If you'll come on up and stand right next to the witness stand, Deputy Gordon's going to swear you in.
Basically, regarding we swear affirm that the testimony you will give will be the truth, the whole truth, and nothing but the truth, so help you God. Where I see, can you state and spell your name for the record?
John Michael Bush, JOHN MICHAELBUSCH.
Thank you, Mr. Bush, and thank you for your patience this afternoon. I'll make this quick. Where are you currently employed?
Hickory Real Estate Partners.
And I've been referring to that as HREP so far. Is that okay with you?
That's fine.
All right. Does HREP have a physical office location?
We do.
And where is that located?
2100 Powers Ferry Road, Atlanta, Georgia.
Did you work at that location in December of 2023?
I did.
And are you generally familiar with HREP's contract with Mr. Dunn to purchase the property located at 5845 Lee's Mill Road?
Yes, I'm not familiar with all the intimate details, but generally aware.
What's your role at HREP?
Acquisitions officer and then development partner as well. But we truncate all of our deals where there's one acquisitions officer who's working per deal.
Okay. Were you the acquisitions officer for,
I was not,
why would you be familiar with it? Just because it's a small firm?
because we have 6 people in the office.
Okay.
And your general understanding of HREP's contract with Mr. Dunn, did you gain some sort of awareness of the tenant that was at Mr. Dunn's property?
Yes, I did.
Did you understand who the tenant was?
Yes, it was VBT LLC, which did business or does business as Atlanta South Bus Repair.
And did you know who VBT's principal was?
I did. Through people in the office. I didn't know him personally, but through folks in the office.
In November and December of 2023, had you heard kind of about your coworker's experience with Mr. Smith?
Yeah, my understanding was when they went to make their initial inspection, that he refused to meet midweek and forced them to meet over on the weekend. And while they were making their inspection on a weekend, he was acting strange outside the property, doing some weird things, making some comments to my partners who were on site, making everyone out there feel uncomfortable is kind of what was relayed to me.
Okay. You weren't actually there, but you did have that kind of understanding during this time frame.
Yes,
All right. Were you at the HREP office on December 12th, 2023?
I was.
And were there any other employees at the office that day?
Yes, Dara Tab and then Davis Maloof were also there. Which one? Dara Tab, it's Dara and then Tabb. And then Davis Maloof. Maloof is spelled Malouf.
At this time, were you aware of Mr. Smith's comments to Mr. Costin regarding bad things happening to HREP?
Yes, I was.
And were you aware that that comment was tied to HREP pursuing the lease mill transaction?
And pursuing the transaction, yes.
On December 12th, 2023, did you have any interactions with Mr. Smith?
I did.
And where was that interaction?
I was walking to the restroom, and as I was approaching our door to get into the main common area of the office, I was startled because I was actually on my phone. I saw a figure in the front of the office. We don't really have a reception area. It was just kind of posted up at the very front of the office in two little chairs. That's where the interaction began.
We've talked a little bit about HREP's office so far, but is this kind of a reception area, or describe the area where you see Mr. Smith sitting to me a little bit more?
I would best call it a nook that's just space because of a structural column that's there. There is no reception area. It's a narrow corridor that can barely fit a mini fridge for waters.
Is there any furniture in the nook?
There's two chairs and then a little coffee table.
Have you ever seen anyone sit there?
Not in 5 years.
Have you ever sat there?
I know, not to my recollection.
All right.
The
And
chairs probably have some dust on them.
is that area inside of HREP's office suite?
Immediately inside, but not in the main part of the office.
On December 12th, did you have any prior warning that Mr. Smith would be at the HREP office?
I did not.
And you talked about how you were going to the bathroom and you see Mr. Smith. Describe Mr. Smith's demeanor when you see him.
Yeah, like I said, I was startled at first because I've never seen a person sitting there, and I kind of caught him in my peripheral vision. So I kind of jumped up, and the first thing I saw was he was kind of murmuring to himself, and I would say like subtly moving back in the chair. And when I could kind of come to my senses a little bit, I asked, "Can I help you?" And at that point, he said, "Is Timothy here?" And I thought that was really strange because anyone who knows TJ refers to him as TJ. So I immediately knew he doesn't know TJ. He's acting a little bit strange. And I said, "No, TJ's not here. Can I help you with something direct?" He said, "No, just tell him Emmanuel stopped by."
All right, let's break that down. So first, regarding Mr. Smith's physical behavior, you said rocking and murmuring. Did it seem typical for, I guess, someone in an office building?
I would say no.
And then next, turning to the conversation that you exchanged. So he asked if Timothy is there, correct?
Yes, he did.
And you found that to be unusual?
I found that to be highly unusual. I don't know anyone else who's ever referred to TJ as Timothy if they know him.
He did not want to spell his first name. She had to pry it out.
Yeah.
What does the T stand for?
I think I know the J because of an American Express statement at one point, but I
We don't need to know the J. That's his secret.
All right, so he asked you if, Mr. Smith asked you if Timothy is at the office, what do you tell him?
I said, no, TJ is out of town.
And I think you said that he said one more thing. What was that?
He kind of smirked and said, hey, okay, we'll tell him Emmanuel stopped by. And if you want me to expand, that's kind of when I connected the dots that who he was, from my understanding of the inspections. And that's when my presence started to feel a little bit heightened awareness and uncomfortability with the whole situation.
Sure. After he says, he does the smirk and he says, tell TJ that Emmanuel stopped by, or Timothy, does he leave after that?
He left close to immediately after that.
And what did you do?
I immediately went to, I can't remember if it was Dara or Davis's office, but I told both of them after I connected the dots of this weird encounter, uncomfortable encounter, and who he was. I said, go lock both of your doors. The tenant from Lee's Mill has been here. I locked the front door and said, let me back in after I go out into the parking lot to make sure he has left. And somewhere in between there, hey, call TJ or call Chase. They were both out of town.
What was the general feeling at the HREP office about your encounter with Mr. Smith that day?
We were very spooked. We were very uncomfortable. And after Dara had called TJ and Davis may have called Chase, we decided everyone needed to leave for the day.
And by that, do you mean you kind of shut the office down
Office was completely shut down.
as a result of Mr. Smith's behavior? No further questions.
Mr. McMaster, questions for Mr. Bush? Mhm. I'm going to ask a question, maybe more than one, while we're waiting on Mr. McMaster. So the extent of your encounter with Mr. Smith was he asks if Timothy is around, words to that effect. And you said no. And then he said, let him know Emmanuel came by, and then he left.
He left.
Okay, it's not that he interacted with anyone else, and where he was, really the only person he could have interacted with was you.
And the only reason, it was in the very front of the office.
Okay. Did he, Mr. Smith, have access to deeper into the office, or would he have to have been buzzed in through some door?
He could have come through. It's open.
Okay, he, for whatever reason, chose to stay in the chair where you found him. And is it your understanding that you were the only person in HREP's office who interacted with, spoke with Mr. Smith?
The only person who spoke directly, yes, with him.
Okay. And after that brief exchange you mentioned, he was gone. You went out into the parking lot and he wasn't waiting there with a crowbar for you or anything?
Not that I saw. I went out and paced around.
Okay. So no threats to you or no direct threats. I understand why this was concerning and alarming. I'm not minimizing that at all. I just want to make sure I'm not missing any component of the interaction.
No direct verbal threats. Was very uncomfortable though.
I hear you on that. Okay. Your turn.
No, you did a great job. No questions for you.
Okay. All right. Any redirect?
No, Your Honor.
You guys go home. I got this. Okay. Thank you, Mr. Bush. Appreciate your time.
I need a buzz out or something.
Nope. You're good. So by your description, that's it for the fact witnesses. I guess, Mr. Ryan, you have some testimony about attorney's fees.
Yes, Your Honor, and we can do that. I'm happy to do that now, or I'm happy to do that after Mr. McMaster has an opportunity to present his case, however you prefer to go about
I just soon stay focused on the substantive counts. And so you're resting in that, to that extent, not waiving any ability to present evidence on 13-611, or in particular, the dollar amounts behind it.
Correct. We're resting on the substantive tortious interference claim, but with the right to present evidence on attorney's fees as well as the amounts and argument regarding punitive damages.
Sure. Great. Mr. McMaster, you have the opportunity now, should you choose to put on any evidence. You don't have the burden here, of course, but any evidence you want in connection with the tortious interference claim.
Your Honor. And I would like to do a 9-11-41 subsection B motion for dismissal.
Okay. Give me a second on that one.
I can read.
I want to see it myself. You said subparagraph or paragraph section
B is
B.
in boy.
Okay.
Would you like me to read that out?
Nope. I'd like you to tell me why you think involuntary dismissal is appropriate at this time.
Okay. Your Honor, they've failed to prove their case. It doesn't matter at this point what we present. They have not met the elements of their case with all the evidence presented. The case that I'll refer to for the relevant law for tortious interference is Kinson Cook of Georgia, Inc. versus Huey Mitchell. And the citation is 284 Georgia Court of Appeals 552. The page citation is, well, I have the one for the reporter, but not the.
That's all right. Tell me what you think that case holds and
Yep.
How that's helpful.
Okay. And the elements are to prove tortious interference, the plaintiff must show improper action or wrongful conduct by defendant without privilege. 2, the defendant acted purposely and with malice with the intent to injure. 3, the defendant induced a breach of contractual obligations or caused a party or third parties to discontinue or fail to enter into an anticipated business relationship with the plaintiff. And 4, the defendant's tortious conduct proximately caused damage to the plaintiff. But there is a 5th element, which I addressed earlier. And that is the defendant must be a stranger to both the contract at issue and the business relationship giving rise to and underpinning the contract. Thus, all parties to an interwoven contractual arrangement cannot be liable for tortious interference with any of the contracts or business relationships that underlie such contractual relationship. Now, there's an even better case to address what is a stranger and what isn't. Let me pull that up. And that is Parnell versus Sherman and Hemstreet, Inc. And the citation is 364 Georgia Court of Appeals 205, and that's from 2022. And I'll go ahead and read the relevant portion from that case. To be liable for tortious interference with business relations, one must be a stranger to the business relationship giving rise to and underpinning the contract, And when a defendant had a legitimate interest in either the contract or a party to the contract, he is not a stranger to the contract itself or to the business relationship giving rise thereto and underpinning the contract. Furthermore, the fact that a defendant did not sign the contract does not preclude a finding that he was no stranger to the contract. Okay, Your Honor. My client's name, Mr. Smith's name, and signature are on a lease that is attached to the contract at issue. That's the contract that was interfered with. That's the contract they are claiming caused them damages. All that did was induce them to create a second contract, and no one's alleging that he has interfered with that contract. I understand him being a tenant on the property may impact something, but that belongs in a landlord-tenant case or a breach of contract.
I want to make sure you're not splitting hairs too much, because I'm following your point, but you said, hey, there's this whole other contract now and no one's alleged interference with that. What's your basis for saying that in the counterclaim, Mr. Dunn has only focused on the unamended CSA as opposed to the amended CSA?
I'm making an argument that the second one is not interfered with.
Okay.
The first one.
Got it. You're not saying they didn't argue that the second one was interfered with. You're saying they may argue that, but they are incorrect. There has been no interference with what you're calling the second contract, which is basically what the thing looks like with the amendment attached.
That is one of my arguments, Your Honor.
Mm-hmm.
My other argument is he is still not a stranger to the second contract.
Okay.
Either way. So they never meet the stranger element.
Excuse me, how is he not a stranger to the second contract, which is now saying we, HREP, need to obtain the property with no tenant. We want it free and clear of occupants. How does that new landscape not turn VBT into a stranger? I see that your point when we're talking about the original contract. Heck, it's, you know what, the tenant comes with it. This is part and parcel. But with the new contract, it says we're buying this land only after it is tenant free.
Correct, Your Honor. And so his right as a tenant under landlord tenant code, dispossessory actions, those are in Clayton County. That belongs, what they're saying is his dispossessory rights that he's acting upon in Clayton County in a different case, which I would argue are privileged, are interfering with this new contract. That belongs in that case. It's dispossessory law, breach of contract law, maybe, allegedly. But it's not a tortious interference with the contract because it is privileged. But I still argue he is not a stranger because he has an interest. He has his landlord-tenant rights still.
When you say the dispossessory action is privileged, tell me what you mean by that.
Okay, so it's actually under 44-7-2. And tenants and landlords have rights to the landlord-tenant dispossessory proceedings under 44-7-50.
Mm-hmm.
And those are non-waivable on a residential lease. But they still exist for commercial leases. If they didn't, they would have locked them out, threw them out, and we wouldn't be there in Clayton County.
Right.
So it's a right to petition. It's right to landlord-tenant code. So it's a statutory and a constitutional right.
So I think maybe I'm following now. You're saying insofar as Mr. Ryan might argue, look, VBT is interfering with Mr. Dunn's contractual rights because he's fighting the dispossessory and he won't leave. you're saying he has a right to fight the dispossessory. And so that can't be tortious interference. That's a privilege act to exercise his right to legally resist a dispossessory. Is that a fair summary?
100%, and that's element one to the Kinson case.
Okay,
It's privileged at that point.
okay. But that's only one basis for the interference. There is the interference of we couldn't do the inspection, all those kinds of things. And that part, I guess you wouldn't say is privileged. If I were to find persuasive the evidence that Mr. Smith, made the inspection difficult, impractical, et cetera, and thereby slowed things down, that's not, I filed suit or I am opposing the lawsuit in Clayton County.
Well, Your Honor, he has the right to possession of the property they're trying to inspect. So again, he's no stranger.
So he could say, I don't want you guys to come during business hours. I want you to come on a Saturday because it's busy during the week and it's gonna be weird having people climbing around on the roof.
100%, and we're actually covering the two elements, privilege on one level.
And then not
Not
stranger. Okay.
The whole issue is he's not a stranger. That's the whole issue of the entire case. I would say the easiest element to address, but again, it is privileged. Okay. One other element, Your Honor, as to why they cannot prove their case, and that is they never really proved their damages. And I understand they may have shown damage occurred, but what has to occur is not just any damage. It has to be the proximate cause and foreseeable. And I even asked the HREF, or was it HREP, Mr.
Costin?
TJ, why not put your money somewhere else? And he kind of didn't get it. And I understand but the reality is this, it's not at the forefront of anyone's mind that, if I, throw my pen over there, the butterfly effect is going to cause someone to lose a lottery. And no one's thinking that way. So it's not foreseeable. And certainly portfolios can go the other way. So they fail to meet the proximate and foreseeable damage element to their case, in addition to the privilege and the not stranger requirement. So Your Honor, on those grounds, the case needs to be dismissed under 9-11-41 subsection B. If the court disagrees, then I guess we'll move on with our defense testimony.
Okay. Mr. Ryan, your thoughts about stranger and privilege?
Yes. I think I wasn't quite following the privilege argument, so I'm going to start with the stranger argument.
Mm-hmm.
The stranger doctrine, and I think a good recitation of it can be found in Cook Pecan Company, Inc., v. McDaniel, and that's 344 Georgia App 370. And there, the court, quoting a previous Court of Appeals case, talks about the stranger doctrine regarding essentially where a defendant has a legitimate interest in either the contract or a party to the contract, he is not a stranger to the contract itself or to the business relationship giving rise thereto. So we have a series of cases, which we're happy to provide Your Honor, that kind of discuss this idea of a relationship and how that works. So a common example would be, say, if, it's a bad example, but not a bad example. Say this was a case where instead of Mr. Dunn suing VBT, Mr. Dunn was suing HREP for interfering with his contract, with his lease with VBT. So say if the contract is between Company A and company B, the actions of, say, a shareholder of company A would be protected under the stranger doctrine, right? That person has a legitimate interest in one of the parties to the contract, so their activities cannot be the basis of a tortious interference claim.
But what if the person has a legitimate interest in the subject of the contract, not a party of the contract? Because that's what we've got here. We've got Dunn and HREP working on a land deal for land on which VBT is a tenant. So clearly not a stranger to what's going on. If VBT was on another parcel of Mr. Dunn's in Alpharetta, it would be odd for VBT to be hassling HREP about trying to buy this piece that he has no connection to, but he has a connection physically, his business is on there, and financially he's paying rent. And he wasn't a holdover at the time this was going on.
True.
So
now the legitimate interest, let's take that, right? If Mr. Smith, as the principal of VBT, was communicating regularly via email with Mr. Costin and saying, hey, I hear you want to inspect on the 27th. No, I'd really love it if you came on the 30th instead, because that's better for my business. I have a bunch of trucks coming in on the 27th. It'd be really inconvenient to have people walking around. Or, hey, Mr. Costin, I'm a tenant here. I'd really like to know where I stand once you buy the property. Can I still be a tenant with you?
right.
That's totally an exercise of related to his legitimate interests in the property. What's not?
You are you're giving examples of conduct, but not the interest. I doubt there would be this lawsuit if the counterclaim, if what Mr. Smith had done would have been to engage the HREP people in a discussion of, could I stay? What do I need to do to convince you to let me stay as a tenant? Do X and Y and Z. We'd love the stream of income. We can't guarantee you forever, but we're open to talking about extending the lease. That dialogue didn't happen. But your example springs from the fact, I believe, that VBT is connected to this transaction and have an interest in the transaction because they are a tenant on the land. And so I don't know, I'm gonna have to look at some case law, but it is wrong to describe VBT as the classic strangers. You have no connection at all to this transaction. To Mr. McMaster's point, actually mentioned in the original CSA. Hard to say you're a stranger when you're sort of, hey, I'm moving along with it. I don't mean to depersonalize Mr. Smith and his business, but like the warehouse, like the office, this tenant moves with the land under the original CSA.
Right.
That's pretty connected to the transaction. Things don't go well because instead of saying, hey, could you keep me as a tenant? Maybe he says bad things will happen if you pursue this HREP. Bad choice. But that doesn't extinguish or modify or eliminate whatever connection VBT had to the transaction. He's still the tenant. He's now an ornery tenant as opposed to a non-ornery one. And I'm struggling with characterizing the tenant on the land that is the subject of the contract as being a stranger to that. I get it that the contract was not it's not a tripartite contract.
Certainly.
Mr. Smith he didn't sign anything, nor would he need to sign anything because it wasn't his land. But he had a possessory interest in it. I guess maybe that's where I'm coming down is it seems like there would be case law out there that says, the person with a possessory interest in the land that is the subject of the contract between the two other parties is not a stranger to that. Or there would be a case by now that says, actually, they are a stranger. It seems peculiar, but they are a stranger because they have a possessory interest only and not an ownership stake. And the owner has an absolute right, unless it's encumbered in some way, like a right of first refusal, which did not exist, I found in this case. The owner has an absolute right to sell it to someone else. And it will be burdened by that tenancy, but the tenant has to go with the flow just like the building might. But you were trying to just what if it was company A and company B?
And that was a bad. The idea is that it's an interest in the economic outcome. It's an economic interest in the relationship and in the contract. And VBT had no economic interest in the relationship, and in fact wasn't asserting a right. There is a case, and I don't have it on me right now, that we cited in our summary judgment briefing on the tortious interference, the 1985 Court of Appeals case that dealt with a holdover tenant situation, and where the Court of Appeals found that the threats of that holdover tenant to, hey, I'm going to make your life difficult, I'm going to prevent you from following through on your intended course of action as either landlord or first level tenant, and he was a subtenant. And the court found that that was a basis, or was a colorable basis, for a jury to find tortious interference.
Oh, okay. That's the kind of law I'm looking for.
And it is slightly distinguishable, I will admit, because that was a context where I believe that tenant, at all points in time in the case, had been a holdover tenant.
No, I appreciate it. You said holdover tenant, but it's still the same structural dynamic where this person has a possessory, the holdover tenant at least was on the land or in the house at the time. And certainly that's where we are now. With Mr. Smith, we weren't at the time, but that's much more parallel than, well, it's company A and B, and we've got this company C that actually is occupying the land.
Right. I think what I'm getting at is a lot of these cases, they also talk about this concept of the kind of, what is the web, the contract language?
Interconnected.
The interconnected,
The interwoven contractual agreement.
obligations, or what is it?
I mean, what they say in Judge Dillard's opinion.
Interwoven contractual arrangements.
Yes.
Right. And what you're seeing in those types of situations are most, like a common example is buyer, seller, people of a piece of real estate, and the seller's lender. Or so the seller's lender is not a stranger to that contract because he has an economic interest in the sales proceeds. Or a developer, buyer, and the project manager hired by the buyer. That contract manager and that relationship with the buyer prevents there being any interference there. So that's the interwoven web of arrangements. That's not what we have here. We have a static lease arrangement, and a lease arrangement where there's no economic interest or benefit to VBT flowing from this sale between HREP and Mr. Dunn.
I mean, VBT may disagree, but I see your point that it's not that VBT was providing some service for one of the two parties to the deal, and the aggrieved party said, well, our contract would have worked out, but your service provider scotched it, gave a bad survey. We didn't like the survey. That's interfering with the deal. Like, well, no, they just did what they're supposed to do. And they have a connection to this deal because they were brought in by the seller or the buyer to do the survey. Okay.
On the privilege piece, with respect to, I think reference was made to the right to oppose a dispossessory. I think that is splitting hairs and putting kind of a legal cart before the factual horse, in terms of, yes, he's able to fight a dispossessory when it comes up, but that doesn't change the fact that his right to possess the property ceased under the lease on March 1st, 2024. So I think that would be my comment there.
Okay.
As to the remaining, I didn't hear him undercut any of the other elements, but I think the testimony clearly demonstrated damages flowing from the interference, and the fact that the interference caused the changes to the contract and the delay.
Okay. Mr. McMaster, I'm going to defer ruling on your motion, and you can renew it at the close of any presentation you make. I'd like to you call it the 1985 case, but whatever case you're referring to, Mr. Ryan, about the
I'll pull it up right now.
Real estate transaction where the holdover tenant was deemed to be a stranger to that transaction and thus could interfere. But you can just put that in email or whenever. I don't want to, we only have about 30 more minutes, which doesn't mean you need to cram your presentation in. We will need to reconvene. Obviously, we've got the whole piece of the attorney's fees we still need to work through. So I guess I'll actually leave it up to you, Mr. McMasters, if you want to get started with, I'm assuming you're going to call Mr. Smith. If you want to get started with that, if you know your direct is going to extend beyond the next 25 minutes, then we can start it. Or if you want to get through all of it in one setting, we can get another date.
Your Honor, I'd say we'd probably all like to go home. My client would, and I think that'd be better because I cannot tell how long this will take.
What's your best guess, not for the cross-examination, but for your presentation?
Probably 20 minutes.
But if it was 20 minutes, we'd finish the direct.
Well, I know, and then they gotta go, and then we gotta redirect, and I'd rather do it all at once.
Okay.
I think that would have more integrity to the whole process, to be honest.
All right, Mr. Ryan, your thoughts?
Let's get the direct done, Your Honor, if it's my choice. I'd be curious to hear when reconvening may occur.
We'll look and we can sort that out, but
But I have my anticipated cross is incredibly brief, so I imagine that if the direct is gonna be 20 minutes, that we could get the entire testimony done.
okay. It'd be great to close out that part of the record. We'd need to do argument. We'd do that at another time. So if you think 20 minutes, then the pressure will be on to keep the cross short. I think that's sort of where we are.
If that's how the court wants to do it, I think it's a clean stop right now, but whatever you decide.
Well, let me look, because we're going to have to reconvene anyway. I know I'm bouncing back and forth on this, but we will not finish everything today. So let me see. Okay. No, you can pause. We can go off the record. We'll get back on the record, so don't shut down, but we can go off the record right now. How does Friday the 13th look?
Seems unlucky, Your Honor, but it's unlucky for both parties, so that's fair.
It is. And I should be clear, if we started at 10:30, is that morning open? I'm just going to the first date. I have more after that, but.
That's your first available date, we can take it, Your Honor.
Okay. Let me give you one other option. Oh, no, we should take that because then I start a 2-week criminal trial calendar.
We'll take it.
So, line up one court reporter, not two. And let's do 10:30 on Friday the 13th, which is less than 2 weeks from now. We will start with whatever you want to present in terms of evidence, in sort of opposition to the counterclaims. When you rest, we can revisit, and by then I'll have had a chance to read the 1985 case. We can revisit I'm going to call it motion for directed verdict. And then we can pivot to attorney's fees. Okay? I should have said we're back on the record, but you got it. Excellent. We need this guy back. Okay.
I have that 1985 case that I can cite to you now,
Please.
and I will likely have some more when we reconvene.
Good.
It's Tedford v. Roswell Village Limited. It's 173 Georgia Appeals 780.
Okay. And you understand my interest. It's finding, if there is case law along these lines, but maybe it's less distinguishable because it's not a holdover tenant, but it's someone who's sort of in the middle of whatever the transaction is, and yet he or she is deemed a stranger, even though the outcome of this contract could have a fundamental impact on the business or the ability to stay in the place. They are nonetheless a stranger because they're a tenant, they're a whatever it would be.
Sure. Yes, and I will be able to speak to that and as a way to distinguish that from a classic third-party beneficiary situation, which would clearly not be a stranger to the contract.
Yep. Okay. Anything else, Mr. Ryan, you want us to be preparing for the 13th at 10:30?
I believe we have rested our substantive case, so on the 13th, we will, no, as long as we are closing out the bench trial on the counterclaims and then proceeding to the motion for fees, I think we're good to go.
Right, you'll be all attorney's fees then, plus a little case law. And you're welcome before then to shoot an email to Ms. Niles and Mr. McMaster. You don't need to write a bench brief or anything, but hey, look at these 3 cases.
Sure.
The further in advance, the better, because then I can look at that. Mr. McMaster, I will expect you to be ready to go when we start at 10:30 on Friday, the 13th, with whatever you choose to be your evidentiary presentation in opposition to the counterclaim. And once you rest, assuming there's no rebuttal, then we can revisit your motion for directed verdict and we'll have argument. And that'll really be part of your argument will be, hey, here are some reasons, plus remember my motion for directed verdict. And then I'll be able to evaluate all that. We'll still need to talk about attorney's fees, even if I grant your motion, then there wouldn't be 13-611, but there's still the other motion that we were going to work through today anyway.
That's correct.
So, does that work?
Yes, sir.
Okay, thank you everyone for your time. Make sure you settle up with the court reporter.
Thank you. Appreciate your time.